Well, good morning, everyone. Welcome to our coverage now on day 60 of the Aurora Movie Theater Shooting trial. By our watches, the jurors have deliberated for less than 3 hours here in Phase 2 before announcing to the court at 9:55 today that they have reached a verdict. Now, our 2-hour warning has been stretched a bit here because the jurors, almost immediately after announcing they've reached a verdict, also said, "But wait, we've made an error on 2 of the verdict forms, and those needed to be corrected." The judge worked out with the attorneys a process for doing that everyone agreed to, and that is being done. Now we have been informed from the court spokesman and from the judge himself that the verdict will be read at 12:30. Of course, that is in Mountain Time. We are here in Denver, and the case is in Arapahoe County, just south of us in downtown Denver. The 12 jurors are the same 12 jurors who, A, found the gunman guilty on 165 counts, and B, found 4 statutory aggravating factors do exist in this case. In the end, come down to just a single juror could have derailed the process, could have stopped the case from moving forward to Phase 3. They must be unanimous if they are going to move to Phase 3, but even a single dissenting juror could stop the case in its tracks right here today when it's read at 12:30. Of course, a quick verdict certainly would suggest that it was not difficult for them to reach a consensus, and that means that certainly in our eyes it makes Phase 3 appear very likely. But at this point, of course, we are waiting until 12:30 to find out what the definitive verdicts are from these 12 jurors. And again, 9 women, 3 men, the same who convicted him, the same who found the aggravating factors, and now the same who have been deliberating just about 1 hour on Thursday and something around 90 minutes this morning before announcing that they had reached a decision. So, something less than 2.5 hours this morning. So at this point, we are waiting for the jury. Here's our plan for the remainder of this live stream, since we are all waiting and very anticipatory of what's going to happen at 12:30. We're going to review the key moments, specifically the testimonies of the gunman's family during the Phase 2 trial of this case. We will periodically cut in, remind you, let you know if we find anything else out from the court. So periodically expect us to jump on here, interrupt the video every 20 to 25 minutes or so, and give you updates on what we have gathered and where our coverage plans are at the moment. But until then, we'll start now with Arlene Holmes, the gunman of the mother, the mother of the gunman, who testified last week about her son, his childhood, and the fact that she did not see this illness, this mental illness that's been testified to on his horizon. So right now we'll start with Arlene Holmes.
Good afternoon.
Good afternoon.
Is James Holmes your son?
Yes, he is.
Have you sat here every day for this trial?
Every day except for 2. I had to go home to San Diego for 2 days. Every other day since April 27th, yes.
Has that been something that's been difficult for you?
It's very difficult and painful and tragic, yes, for everyone.
Have you heard then the testimony of most of the experts that have talked about your son's serious mental illness?
Yes, I have.
Is that something that also has been hard for you to listen to?
Yes, it is.
Before July 20th of 2012, did you know that your son suffered from a serious mental illness?
No, I didn't.
Now, we'll talk about some of this, but you've had some concerns about your son as he's been growing up, is that right?
That is true.
At the time in his life, the various times in his life that you had some concerns, did you ever think it was some sort of serious mental illness like schizophrenia?
No, I did not.
How can that be?
He was the most responsible person I knew, my own son, He managed his finances, looked after himself completely, went to school every single day without complaint, did all his chores without being told. You tell him once what he needs to do, and he did it. He never harmed anyone ever, until July 20th, 2012.
As you sit here today, do you still love your son?
I still love my son. Yes.
Why?
Because I understand he has a serious mental illness, that he didn't ask for that. Schizophrenia chose him. He didn't choose it. And I still love my son. I still do.
I want to talk to you now a little bit about that time in the months before July 20th of 2012, okay?
Okay.
Now, I understand was it your main method of, what was your main method of communication with your son?
Email.
And I said James Holmes. What name do you call him by?
I called him Jimmy until high school, and now I call him Jim.
Why was email the main mode of communication that you had with your son, Jim?
He never really liked talking on the telephone. He did once in a while, and sometimes we'd call him and leave a voicemail, and he'd respond by email.
Was there a time that you had to actually practice with him about talking on the phone?
I did.
Can you explain that to the jury?
Yes, he was in middle school, and there were times when he had to communicate by phone. It was before the days when everybody just texted and tweeted and really didn't call each other. There were times when people actually called each other, and so we would have a dry run and practice using the telephone so that he would not get too stressed by having to use the phone.
How old again was he then?
Middle school.
Cool. Okay.
Yes.
So when sort of email came about as a primary mode of communication, did he take to that?
Yes.
When he went away to college, is that how you communicated?
Yes.
And the same for while he was at graduate school here in Colorado?
Yes, email.
Okay. Even when you communicated with him in email, was he verbose? Did he speak a lot, even in the emails?
No, but if you're asking me about the time in Colorado, it got shorter and shorter in
Okay.
his emails.
When did you notice that it was getting shorter and shorter?
Probably May, June.
Was that alarming to you or concerning to you in some way?
I was concerned because when he called me on what I thought was right was to encourage him and to remind him that he did well in presentations back in high school era. And so I just kept telling him, just keep trying, but I didn't realize that his loudest cry for help was his silence.
Somewhere in that period of time, did you get a phone call from a Dr. Fenton?
I got a phone call from Dr. Fenton on June 11th, 2012.
And did she express to you some concern that she had about your son?
Yes, she said that she saw him for social anxiety and that he had come to her for this problem. But initially, the very first thing she said was, "Did you know that he was going to quit school or had quit school?" And I said I suspected it because he said he was just struggling. It wasn't fitting with his personality to do these presentations.
Mm-hmm. Did she ever tell you she had concerns because he had expressed homicidal ideation?
No, never.
Do you wish she had?
Of course I do. Of course. We wouldn't be sitting here if she had told me that.
Would you have been out here the next day?
I would have been crawling on all fours to get to him. He's never said that he wanted to kill people. She didn't tell me. She didn't tell me. She didn't tell me. She didn't say that she thought he might be psychotic.
Your Honor, asked an answer.
Sustained. Wait till the next question, please. Next question.
Did she tell you he thought he might be psychotic?
She did not.
Did she tell you that, did she leave you with the impression that it was okay for you to tell your son that she had talked to you?
I said, "Did he give you permission to call us?" And she said, "No, he doesn't want to worry you." And I said, we can call him and not mention that you called." And she said, "That would be good."
Did she tell you that he had quit counseling?
No.
Did you have some relief in this idea that you thought he was still in counseling with her?
Yes, I was reassured by her phone call. She said he's coming for help, and that at the end of the month he wouldn't be a student anymore, so his student insurance didn't cover it. And I said, "We work, we have money, we can pay for it." And she said that would be fine.
Did you continue to communicate with your son after that? Did you communicate anything to him about that conversation?
No, we called him as soon as my husband got home. Dr. Fenton called about 4 o'clock California time. And so my husband got home from work at 5, and we called him and left a voicemail, and he didn't call. So we emailed, and he said, "It's true. I've quit school. It just wasn't a good fit." But we didn't tell him that we talked to Dr. Fenton.
Did you ever communicate again with Dr. Fenton?
I tried. She said, "Call me anytime," and gave me her cell phone. And we called her, but she did not call back.
What did you ask her to call you back?
Yes.
Okay. You left her a message?
Yes, the voicemail.
And you never heard from her again?
Right.
Do you recall when it was that you left that voicemail?
Well, she first called June 18th, and then we went to Monterey on the weekend, so the following Monday would have been, she called June 11th to me. So we went to Monterey, so the following Monday would have been June 18th. So it was about June 20th, 2012.
Okay. There has been a lot of talk by the prosecution about the continued emails that you and communication you had with your son in May, June, and July,
Yes.
and that he never communicated to you what he was doing at that point in time. I want to talk to you about sort of the nature of his communication with you historically. You do recall that he communicated initially with you it would have been the fall of 2011 about his girlfriend?
Yes.
And you had to actually ask him to let you know what her name was?
Yes.
Okay. And you also communicated with him throughout the year with regard to various sundry things, what you were doing. Girlfriend?
Yes.
Okay. What was your biggest concern at that point in time for him?
That he was not sitting alone playing video games.
Were you concerned that he might be depressed?
I was concerned, yes. If you've lost your girlfriend and your job and your plan as far as grad school, yes.
Were you in any way ever concerned that he would act violently?
Never. I was totally shocked that he used a gun. We never had guns in the house. We never were hunters or target shooters. When I heard, I thought, how does he even know how to use a gun?
In that phone call, did he ask you questions about your daughter, Chris?
A lot.
Okay. Did he usually ask you about Chris when you spoke to him on the phone?
He had just talked to me on Mother's Day, and he asked about Chris then, and Mother's Day, May 2012.
Okay. And then he asked about her again on July 4th?
Quite a bit of that conversation was about her. He wanted to know why she hadn't passed all her classes, and she wasn't with us at the time we called. She was with her friends, but he said, please tell her that 5 classes is too many. She shouldn't have taken so much, and that it's too hard in college to do that much.
Was there anything about him during that conversation that was different to you?
It lasted a long time, and usually he's either quick on the phone or email, and he must have talked to us for a good half hour. That's unusual.
Did he seem sad to you? Or did he seem happy? What was his expression, do you know?
Neither.
Okay.
Neither, just talking.
Was it an alarming thought?
And his tone of voice was not alarming.
Okay.
No.
After that phone call, did you still plan on coming out to Colorado?
Yes, even more so, actually.
Okay. Was it, in your mind at that point, was it extremely urgent or not?
No. You mean because of that phone call? Mm-hmm. We didn't talk about anything that would have made it urgent.
I want to back up a little bit. He had told you a couple times throughout the school year that maybe this program wouldn't be a good fit, that he was struggling with his presentations.
Yeah. As adolescents, I tried to check in and say, are you sure you still want neuroscience? Because he decided at 14 and never changed his mind. And I said, think it over. People explore options, and whatever you choose should be okay.
Did you ever put any sort of pressure on him that he had to go get some sort of degree, a master's or a PhD?
I did not.
Did you always let both your children know that no matter what they did, you would be there for them?
I did.
And I know you did that with your daughter, Chris, as well, with her music.
I did, yes. I was worried about that choice because it's not so easy to get a job if you choose to be a musician. But I told her we would be supportive of her choice.
Is that something that's important to you as a parent?
Yes.
Let's back up a little bit further to the family holiday you had in December of 2011, okay?
Okay.
Tell how long was that holiday for?
The actual time we went away.
Yeah, the actual time that your son was home was with you.
Okay, I need to think a second. He was ill. He had swelling on each side of his neck. He was tired all the time, and he wouldn't eat. And I asked him, well, he was not feeling well.
Would he kind of sit at the table and stare at his food?
Yeah, he wanted to get up and lie down, and ever since he was born, he's been a chow hound, so I was worried if he didn't eat.
Okay. Eventually, at some point during that vacation, did you and your husband make sure he saw a doctor?
Yes, my husband went with him to Kaiser.
Okay. Now, despite the fact that he came home and seemed very ill, did you all still do a trip to Arizona?
We did. He slept in the car, and we went to Arizona, and we stayed in a hotel because my brother had cancer, and we didn't know if Jim would ever see him again. So we just let the kids sleep, and Jim and Chris he was better after a lot of sleep. They went on a hot air balloon ride together
Okay.
in Arizona.
Did they also stay in the same hotel room together?
They did.
Did they do any other activities together?
Went to lunch.
Okay.
Apples to apples with my brother. That's our usual game.
Okay. And when you talk about your brother, is this your brother Dex?
James Dexter Egan. We call him Dex.
Okay. I want to touch on one last subject from 2012, and that's when you first got to visit your son after July 20th. Do you recall visiting him?
In jail?
Yes.
Yes.
Do you recall when that was in relation to July 20th?
Yes. It was about August 12th.
Okay. Did he
Chopped, like he couldn't just say a sentence. And he didn't look at us. He just looked down, and his hair was red, and of course he was in jail scrubs, not clothes, and his feet were shackled, and his eyes were kind of darting back and forth. They weren't like now he can look, he's looking at me. But in 2012 they were just not controllable and physically different and unable to communicate in the same way as usual.
Was he still able to understand your conversation?
He did.
But he just had difficulty finding the words?
Yes, he wasn't talking gibberish, but it took forever to get each word out and put it into a sentence.
That verdict is going to be read at 12:30. Of course, I'm speaking in Mountain Time. The jurors, they got the case, they got the deliberation forms in hand on Thursday afternoon, but they had less than an hour to work then. Friday, of course, was a pre-scheduled day off, something that we knew was going to be a day off since the start of the year. And now, of course, they resumed deliberations at 8:30 this morning, only to say at 9:55 that they have shows you the form that the jurors themselves had to complete. So as in previous situations we have just one sample, but the jurors themselves were given 24 copies of this, one for each of the 2 counts of murder. Remember, there were 2 different varieties of first-degree murder for each of the 12 victims who were killed, so 24 total, 2 for each of the victims who were killed. They each had this multi-step sort of process. So, Phase 2 sentencing verdict question. Does the jury unanimously find, beyond a reasonable doubt, that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing? So what does that mean? That means it's weighing the mitigating circumstances, the 6 proposed by the defense, against the 4 already confirmed by the jury from the prosecution. Now, all 12 jurors, and this is the first time we've seen this, all 12 jurors will have to sign this, with the 4-person signing in the last line here, in order to move on to Phase 3. But they do not need to single themselves out. Even though it takes only one juror to derail the process, to stop us here and sentence the gunman to life in prison without the possibility of parole, it only takes one. Only the 4-person has to sign on that line. Now, of course, there are asterisks here that explain this in a little bit more detail. If the answer is yes, the 4-person shall sign on that one designated line, while the rest of the jurors will sign on the other lines. In that event, the hearing will continue to Phase 3 on this count. Of course, each count is individualized. But if the verdict is no, that the aggravating circumstances do not outweigh the mitigating circumstances, or the mitigating circumstances are given more weight by the jury, in that event, the hearing will end with respect to this count, and, based solely on this verdict, the defendant will be sentenced to life in prison without the possibility of parole on this count. So, is it likely that they'll be dividing these counts? No, not likely at all. They have not done that. The only time that this jury has divided a count or changed a count was with respect to the guilt situation regarding the 3 people who were injured in Theater 8. Remember, the projectiles 9. That is the only time, however, that the jury has divided any of the counts, and certainly they've never divided any of the murder counts, despite the fact that there are 12 of them, 12 victims and 2 counts for each victim for a total of 24. Those have never been divided, and so it is very unlikely. Whatever you hear, the first one read is almost beyond certainty going to be the same verdict for all 24. So the first, whatever's read first, it's very likely to be the same for the next 23. But of course, it does start with Jonathan Blunk's verdict form for the first count of murder that relates to his death. His is the first listed count. Of course, those came in alphabetical order, and his name being Blunk does come up there at the beginning of that list. So at this point in time, we are just over 1 hour from the reading of this Phase 2 verdict, the reading of this jury's discussion. So it's important to note how the jury was asked to go about these things. Specifically, this group of 9 women and 3 men, for the very first time, have been asked to consider things outside of the facts presented in court. At the guilt phase of the trial, they were not allowed to consider anything else. At the aggravating circumstances phase, they were not allowed to consider anything else. This is the first time where they're being asked to consider individual reasoned moral judgment. And a lot of that is based on the testimonies from the people who knew the gunman, who testified that they did not see this coming. They did not see the mental illness on set. They did not recognize it for what the defense argues it was. And at this point, that the jury is debating, or has debated that and reached an answer that we will find out in just over an hour. Of course, the family members were the key witnesses for the defense in this phase. We played for you earlier Arlene Holmes, the mother. Now at this point, we're ready to play Robert Holmes, or Bob Holmes, the father. And of course, we will join in for another update in 25 minutes or so.
Good afternoon.
Yep, it's been a difficult experience.
I'm sorry, can you pull the microphone
Yep,
closer to you,
okay.
please, to make sure we can all hear you? You can actually move the microphone
Yep, okay.
so that it's right up, right by your mouth, okay? Thank you. All right, Miss Brady?
Can you repeat that answer? It's been difficult for you?
Yes, it's been a very difficult experience.
And have you heard the experts who've testified that James has a serious mental illness?
Yes, I have.
Prior to July 20th, 2012, did you know he was mentally ill?
No, I did not.
Did you have any concerns about him?
We certainly did. I mean, we know he'd broken up with his girlfriend and he dropped out of grad school. And so we made plans to see him. I assumed he might be depressed, but that was our main concern.
Right. Prior to July 20th, 2012, had James ever confided in you the suicidal or homicidal thoughts that he was having?
Nope, he's never expressed anything like that.
Didn't have any idea he was having these disturbing images in his head?
No, I had no idea he was having intrusive thoughts, disturbing thoughts, or anything like that.
Do you still love him?
Yes, I do.
Why?
Well, he's my son, and we always got along pretty well, and he was actually really an excellent kid.
How did he seem when he was about ready to move to Colorado?
He was looking forward to it.
All right. Did you help him move to Denver?
No, the way it worked out is I think he hopped in his car and went to Denver by himself, and then we came later and brought his snowboard and some other stuff that he wanted. So
When you came, had school started?
no, I think it was May, so I think he might have started working at these lab rotations that he was doing, and so that may have just been starting.
How many times do you think you saw him, let's talk about 2011, May through December? Do you know approximately how many times you saw him while he was in Denver?
I'm trying to remember whether we saw him at Thanksgiving or not. That I actually don't remember. I know we saw him in December,
Okay.
so for Christmas break.
How did he seem in December of 2011?
In December, he was really sick.
Can you tell the jury about that?
Yeah, he just really looked sick and weak, and he didn't seem to be doing very well at all. And so we took him over to Kaiser, and I guess the doctor checked him out and determined he had mono. And I don't know too much else about what the doctor gave him. The doctor prescribed stuff for him. And
For the mono?
yeah, I guess for the mono.
Okay.
And I'm not even sure what he talked to the doctor about.
And
the doctors don't tell us.
I'm sorry, by the time,
His Uncle Dex and his Aunt, I guess his Uncle Dex, because Aunt T might have been gone by then. So. Oh, yeah, we went over, we drove over to see his Uncle Dexter, and his aunt had already passed. And I guess we also knew, the way he put it was the professor in his second lab got peeved, as I think that was the expression Jim used. And so we knew some things weren't going very well there.
right, and were you speaking to him on the phone during this time to get this information?
No, it was mostly email.
You did speak to him, though, on 4th of July, 2012.
Yes, we did.
Can you tell the jury how James seemed when you spoke to him on the phone? First of all, did you have to arrange that, or how was it that you had a
Yeah, I
phone
think we
call?
did set it up by email, as I recall, or some either text or email, I'm not even sure which. But we did set up a phone call for around the 4th of July. And so we talked to him then, and historically, when we talk to him on the phone, we get yes or no answers and, little content. But this time, it was quite different. We were concerned that because at that point, we knew he was dropping out of school. And I think he had sent an email stating the fact that he was not going to continue at school and tell us. And I kind of personally put it down to HIPAA type stuff. I know there's these privacy laws that she didn't tell us much, and that's part of what motivated us to get on a call with Jim just to find out what's going on. But she also mentioned that Jim had not given her permission to talk to us. Okay, so the other part of it is we've got to be able to talk with him, I guess, without, we knew he didn't feel this was a good fit, so we wanted to kind of make sure he wasn't too depressed about it and would be able to kind of move on from that.
And did you guys try and get back in touch with Dr. Fenton?
Yeah, decent academically. Arlene, I told Arlene that we should call her back and say maybe he's got Asperger's or something.
Did
And
you,
so-
did,
yeah,
did
my
you
underst-
or Arlene ever speak to Dr. Fenton again?
My understanding is Arlene left a voicemail and never heard from Dr. Fenton. So we had the one call with Dr. Fenton, and that was it.
Okay, and then you were going to tell the jury about the July 4th phone call.
Yeah, so we did finally talk to Jim, and in July 4th, I mean, my main goal was to find out, is he really depressed? Because I think I'd sent him an email recommending that he gets counseling. I was just hoping that would sort of, if he was going to see a shrink, he would keep going. And so, but anyway, so on the 4th of July, we wanted to sort of see, because I mean, we were thinking about flying out on the 4th of July. And so we called him, and we had what for us turned out to be a really long conversation. So he was talking quite a bit, and, and he didn't seem depressed, and, he certainly did seem to be making sense and everything, so it wasn't that kind of chatty. But anyway, so we had a talk, and so at that point, I think we were telling him, we were going to arrange to come out and see him. Because I think I'd already told my boss, I'm worried about our kid, we probably got to make plans to see him. And so it was somewhere in that time, so.
All right. Given the sort of history with James on the phone, did his chattiness and willingness to talk a lot strike you as odd for the way he usually is?
Yeah, it was unusual, but it wasn't alarming.
Okay.
Okay, so, I mean, he usually didn't talk that much, and so that was kind of surprising, but I was looking for clues of depression, which would be kind of, I thought, even less talking, so.
When you, during the spring of 2012, were you calling him and leaving messages trying to get in touch with him?
Yeah,
And was he returning those calls or no?
no, but he would sometimes answer emails, so it's not like we were having no contact, but we were finding it hard to kind of have phone contact with him.
Your Honor, if I can approach with D-TR-393, 394, 395, 396.
Yes.
Calling him, asking him how he's doing, asking him if he needs anything.
And
So-
so are these examples of your attempts during the spring of 2012 to try and get in touch with James?
Yes,
Your Honor, I would move for the admission and public.
Yeah, Sunday afternoon, 5 here. I guess it's like 7 your time, or was it 6? I'm not even sure. Anyway, everything's fine here. We're just calling to see how you're doing and find out if you need anything. Okay? Not too much else. Arlene, did you have anything else you wanted to ask? Oh, Arlene says love you. We love you too, and so take care. And I hope everything's going fine. Give us a buzz or send us an email. Okay? Okay, take care, and we'll talk to you soon. Bye-bye.
If we can publish 394, please.
Hey, Jim, this is Dad. I was just calling to find out how you're doing. Nothing special going on here. It's cloudy, and we're just thinking of you, okay? So I hope everything's going good. Drop us a line if you feel like. Send us an email or a call. Anyway, we'll talk to you soon. Bye-bye.
395, please.
Hey, Jimmy, it's Dad. I'm just calling around, I guess 3 o'clock your time, 1 o'clock our time on Memorial Day, just to find out how you're doing. You're probably out and about, probably maybe going to a Memorial Day barbecue or something. Anyway, nothing special to report. everything's fine here, and so I guess just wanted to call and say hi. Anyway, you take care, and we'll talk to you soon. Okay, bye-bye.
And 396, please.
Hi, Jim. This is Dad. I was just calling to find out how everything's going there. We kind of miss you here, and we're hoping to sort of stay in touch. We haven't heard too much from you recently. If you get a chance, give us a call, and we'll...
It's connected to the other 3 voicemails.
Yes, there are.
Can you just read them off for the jury, please?
Sure. The first voicemail was April 1st. The second voicemail was April 29th. The third voicemail was Memorial Day, which is May something or other, and so end of May.
Late May.
Yeah. And then the last one is June 12th.
Now, as you're leaving those voicemails, you express to James that you're a little concerned because you haven't heard from him. Is that true that you had not heard from him much and were a little bit worried about that?
Yes, that's true.
Were you planning on going out to see him and check up on him?
We were planning, yes, I mean, definitely after we knew he wasn't going to continue in grad school, we were definitely going, and I would say we would probably go anyway, just to visit him.
As you were leaving those voicemails, did you have any idea what James was doing during that time?
No.
And you've heard the testimony about what he was doing during that time.
Yes.
Did you have even an inkling that any of that was going on?
No, it didn't even cross my mind.
If Dr. Fenton had told you how sick Mr. Holmes was, would you have done something to try and help your son?
Sustained.
When you had last seen James, which was in December of 2011, did you see him make any facial expressions that you thought were unfamiliar?
Yes, I did notice a couple of things. One is we were just kind of standing around, and I did notice kind of an odd facial expression, which a later picture of his kind of reminded me of it.
Now, if I can approach with D-TR-371.
You may.
Now, Mr. Holmes, is that the sort of facial expression you were trying to describe?
Yeah, this is a picture which reminds me of it.
And was in December of 2011, was he also making movements with his face that maybe you could describe or show to the jury that you thought he was doing that you had not seen before?
Yeah, it was more like this, just kind of odd facial expression. I don't know, it's hard for me to describe.
Okay.
And then he also wasn't making very good eye contact.
And that was something you noticed even back then?
Yeah, it was something I noticed back then, and it was part of the thing that when we sent that voicemail about Asperger's, it was kind of, that's what got me thinking about stuff like that, you know, facial expressions and lack of eye contact.
Mr. Holmes, where were you when you heard about what happened in the theater?
Arlene and I were asleep in San Diego.
Right, and how did you learn about what happened?
We received a phone call from somebody in the media who had said there was a shooting. And my first thought, of course, was that Jim had been shot. And so, you know, my initial impression was it was probably some gang thing. But then
And you thought that Jim was the victim?
yeah, didn't occur to me that he would be the shooter.
Right. What did you do with the information that he was the shooter? What did you do after learning that?
Well, once we found out, very shortly thereafter, the media arrived in front of our house, along with the police and the FBI, and then basically I just sent an email to work saying I had a family emergency, and then I booked a flight to Denver.
Right. You came to Denver?
But yeah, I guess.
Is there any reason why you haven't seen him more than 3 times?
Well, we got to see him shortly after the shooting while he still had his red hair, and then that one the sheriff arranged. And then, from what I understand, Jim doesn't allow any visitors, and so we hadn't been able to see him for a long time for that. And then every once in a while, we've been making like 12 or something trips here for the trials and the preliminary stuff. And so usually every time we come, we try to make arrangements with the sheriff to see if we can see him. And it doesn't happen very often.
When you saw him with the red hair, did he seem like the son that you knew?
No, he was clearly really messed up. And, his eyes were bulging out, his pupils were dilated. He was able to talk to us, which was good. And he actually told us he loved us in the defense. And so that's part of the reason I don't think he's written any letters, and I don't think he's going to until the trial's over.
If assuming Mr. Holmes stays in jail or in prison, do you and your wife still intend to try and visit him if he will see you?
Yes.
And will you write him letters?
Yes, we will.
And will you always do that?
Yes.
What is your fondest memory of your son?
I think he was happiest when he was playing soccer as a kind of middle-aged, young kid. So probably in the Oak Hills time, I think that was probably the happiest time of his life, and probably ours too.
Your Honor, can I have just a moment?
Yes.
Thank you, Mr. Holmes. The prosecution might have some questions for you, okay?
Sure.
Okay, you had a conversation with your son on July the 4th where you talked about...
Well, we're pausing this now because it's been about 20 or 25 minutes, and we want to periodically jump in, remind everyone what we're waiting for. At 12:30, of course, the verdict in Phase 2, this mitigating factors phase of the Aurora Movie Theater Shooting trial. What we were just listening to was the direct examination of Robert Holmes. We will get back to his cross-examination later as we continue to wait the final 38 minutes or so until this verdict is read, but we want to take a few minutes to remind everyone of the context and, be journalists for a moment and hopefully inform some of you about this very confusing process that Colorado has. So if we pull up our computer screen, we'll see a zoomed-in frame from this Phase 2 sentencing verdict form. Of course, if the jury finds that they want to move to Phase 3, that the mitigating circumstances are not outweighed by the aggravating circumstances or factors, they must all sign on all 12 lines. They must all sign on the 12 lines, one for each juror. If any one juror, even a single juror, does not unanimously agree that they should move on, only the foreperson signs, so we will not find out who dissented, but we will find out if they dissent in one way or the other. It's important also to look at how long they've spent deliberating. So I promised I would fix this earlier, and I have. In the guilt phase, they spent 3 hours, nearly a day and a half on this. 13 hours. In the penalty phase 1, which was deciding if there were aggravating circumstances, they spent about 2 half days, 8 or 9 hours. In penalty phase 2, they spent less than 3, maybe 2.5 or so. In both of the previous rounds of deliberations, they were instructed to consider only the facts in the courtroom. Last week, however, when this phase began, it was the instructions included the fact that they are allowed to decide based on individual reasoned moral judgment. And I keep leaving out that reasoned part. Individual reasoned moral judgment. So if I've said that wrong earlier, I've gone back and verified the quote. So that means that whatever of factors that the individual jurors find mitigating, it is up to them to decide if they're mitigating. It is up to them to decide how much weight to apply to each one, and it's up to them to make the individual comparison against the aggravating factors. Once they do that, then they're asked to come together as a group and decide, do you agree, I agree, etc., all the way around the table for the 12 of them, 9 women and 3 men, whether they should move on or not move on in this process. Of course, FACE felt was appropriate, not just the 6 statutory circumstances or factors that were presented by the defense and included in the judge's instruction, and not just the 62-point story and theory of mitigation that the judge read aloud for the defense. The jurors could consider whatever they want. In fact, you'll remember that very dramatic moment where Tamara Brady, the public defender, pointed to probably the most infamous and incriminating photos, the mugshots that showed the gunman with the orange hair and then another one with the wide eyes, photos that certainly have been scary and also memorable for everyone who lives here in Colorado. But she pointed at them not as signs of a criminal mind or some such. She pointed at them and said, does that really look like someone who's guilty and deserves the death penalty, or does that look like someone who's going through a psychotic episode? And so she did that very dramatically, very theatrically, but certainly pointed at what could be some of the most memorable and disturbing imagery of the gunman. They rejected the not guilty by reason of insanity plea. They said he is guilty. He is convicted of all of these crimes, 165 counts in total, stemming from the apartment that was booby-trapped, the 12 victims who were killed, the 70 others who were injured. But now it's back again, this idea of mental health as a mitigating circumstance. And it's even provided for in Colorado law, saying that he was not of sound mind, not insofar about 33 minutes away from hearing the verdict read aloud in District Court Judge Carlos Zamora's courtroom. That's Division 201 in Arapahoe County, and I can tell you that the media is starting to arrive outside in force. We've seen some photos, cameras being set up. Everyone is in designated areas outside the courthouse and getting ready for this verdict to be read. But of course, the only way to see live what's happening inside is through this camera that we have available for us, the same camera that we're replaying you footage from right now. So let's go and resume, at least for now, with the cross-examination of Robert Holmes, and we'll provide another update on the tail end of that video.
I imagine a whole bunch of different topics.
July 4th, yeah. I don't remember too much actually about the discussion itself. Arlene might have a better memory of it. It just seemed like it was how was he doing? I mean, I wasn't so focused on the content as just trying to determine whether he was depressed, and he didn't really seem so. And I don't know how much I remember too much about what we talked about. I mean, it's kind of the usual stuff, how he was doing in Colorado. Did he want to stay there? You know, I mean, there's kind of things like that.
Did you online?
We obviously had no knowledge of any of his activities in regard to the shooting.
And is it fair for us to conclude, too, and I think the answer is yes, that all of these other emails that take Mother's Day, that throughout all of those emails, you never had an inkling of the arsenal that your son was amassing in his apartment in Aurora?
No, he didn't. He didn't tell us anything about what he was thinking of doing.
And after that phone call on July the 4th, again, you come away from it with no immediate sense of urgency, of needing to get out there that next day, nothing like that. Fair?
That's right. He certainly never mentioned anything about what was going on.
And in fact, on July the 12th, after you had, and I think your wife had proposed to him, coming out August 9th or 10th?
I think it was the 9th.
His response was, in essence, that's fine. I don't have any plans that weekend.
Yep, I do remember that email.
And you now know that that was just 7 days. See, and which one is this, sir? Sorry.
I think it's D-DR-371, but I'm not sure.
Well, sir, take a look at this. If it's not 371, we'll correct it. Thank you, sir. It looks like it's DTR 371. See this picture?
Yes.
This is a picture that you recognize as a booking photograph, correct? Seeing it, he knew this picture was going to be taken.
Judge, objection, speculation.
I don't know whether he can answer that question, so I'll sustain the objection.
Sir, can you tell from this if it looks like this was a surprise photo?
Objection, speculation.
Overruled. He's saying whether he can tell.
You know, I don't really know the conditions under which this photo was taken.
Fair. One, we don't know,
I don't, actually, I was pretty sure this was taken before that,
and you don't know if, I'm sorry, sir,
because
you
I'm
don't-
trying to remember when, I think I first saw this picture, you know, not too long after the crime.
and you don't know if this photo, well, and forgive me, he doesn't have red hair in this photo.
Yeah, so it's been a while since the crime, so.
You'd agree, too, that we don't know from this, you can't tell from this if this photo was taken after he'd been accused of 165 counts of murder and attempted murder.
I'm going to object to that.
Overruled.
Do you know, sir?
Depends on, I mean, I knew he'd been, you know, accused of this crime, right? So this is after the shooting, so.
Understood. Thank you.
As, you know,
Oh, I'm sorry, sir.
I mean, I just don't, you know,
Yes, sir.
I don't know whether it was before or after the formal accusation or anything like that.
Thank you. Sir, thank you. Final thing here, after the shooting, you are contacted by a member of the Federal Bureau of Investigations. Do you recall that?
I had a couple contacts. There was one in the San Diego airport as I was going to Denver.
And during that conversation, that FBI agent asked you a series of questions about the defendant. Do you recall that?
I do recall that.
And in fact, one of the things that he spoke to you about was that phone call, that last phone call you had on July 4th. Do you recall that?
I'd always thought that he didn't seem like he was happy, but I didn't get the feeling he was depressed, right? I mean, I thought if he was depressed, he would not want to talk, not, you know, but he didn't seem that way, so.
Do you recall talking with that FBI agent we sort of laid the foundation with shortly after you were notified of the shooting?
Sure.
And do you recall telling him, as you
Judge, I'm going to object. Improper foundation for impeachment.
Overruled.
He hasn't identified the agent, the date.
Sustained.
This was a conversation that you would have had on
July 20th.
July 20th, sir. Yes, thank you for that. And do you remember who the FBI agent was?
I'm sure he gave me a card, but
Can I have a moment, Your Honor?
Yes.
Olascino. Do you remember that name at all?
I didn't pay any attention to their names.
There's another one. James Harold Butler. Do you recall that at all?
No, but, okay.
Do you recall telling them on the 20th, after you were notified of this, in a description of the July 4th phone call, that you spoke with your son as a checkup, you wished each other a happy 4th of July, and you described him as, quote,
All right. Ms. Brady, do you have any redirect?
Yes, sir.
You may proceed.
Holmes, let's follow up with that statement to the FBI. That was at the airport.
Yeah, I was in the terminal waiting for the plane, and then a couple FBI agents approached me, and they took me down to a little conference room under the terminal.
So was it just hours earlier you heard that your son was accused of a mass shooting?
That's true.
What sort of frame of mind were you in when you got to the airport?
Yeah, it was kind of turmoil, so.
Were you trying to catch a flight?
Yeah, I was waiting for the plane.
Were you worried about your son?
Yeah.
Were you worried about your family?
Yes, everybody.
Were you thinking very clearly at that point?
Probably not.
So right here, right now, do you believe that your son James was happy on 4th of July of 2012?
No, I mean, I'm trying to remember the conversation with the FBI agents, and from what I recall, they were interested in whether he had a history of violent conversation. I don't remember saying. I could have said he was happy. I mean, I certainly, what I kind of meant was he didn't give any inkling that he was homicidal or stressed or anything, at least to us on the 4th of July.
And you described earlier how what seemed unusual about that conversation was that he had just quit school and that he didn't seem depressed and that he seemed very talkative, which was unusual for him.
Yeah, we were trying to decide whether to sort of go immediately or kind of go a little bit later, which was more easier for our schedules. And after that, it seemed like he was doing well enough. He didn't seem despondent in any way about dropping out of school. And in some sense, he even gave me the impression that it was, he thought it obviously like to find out more about what's going on, but he would share some information.
Okay. But not as much as you were hoping to get.
True.
Do you know for sure when James was told that he didn't pass his prelims? Do you know whether it was June 9th or June 11th?
I don't know the exact dates, and I'd have to find out, I'd have to look back at these emails again to find out exactly when he told us. But
Okay.
it was shortly after. I guess that's right.
That booking photo from the jail that you were shown, the one that looked like the face that you had not seen on Jim before December of 2011, do you remember seeing that photograph close in time to when you visited him at the jail for the first time?
That's hard. Actually, I don't really remember whether it was close in time or not. I just remember seeing that photo, and it just seemed to remind me of an expression he had.
Do you remember seeing that photo before he went to Denver Health Hospital in November of 2012?
That I still don't remember before or after. Had your son experienced frustration and disappointments in his life prior to going to graduate school? Well, yeah, of course he didn't get into grad school the year before, so that was, I'm sure, a disappointment.
When he was rejected by all 5 or 6 of those graduate schools during that first round, did he react violently?
No, I mean, he seemed, I think he was very disappointed, but he seemed to accept it.
He didn't hurt anyone after that?
No, he wasn't violent, wasn't
He break anything?
mean or anything, so no.
Did he yell at anyone?
Nope.
Did he have any history at all of reacting violently if something didn't go his way?
No, he was not.
Whether you saw a change in Jim. I just want to make sure this is clear for the jury. When your son, James Holmes, was young, he was very social and very outgoing. Is that fair to say?
Yes.
Is that different than how he was in middle school and high school in San Diego?
Yeah, up through middle school, he always ran with sort of a pack of kids, and after middle school, he had much less. He did still have a few friends, but it was a much less interaction.
Did he go outside less often?
Yes.
Did he invite friends over to the house less often?
Yeah, almost never.
Did he go over to friends' houses himself less often?
Seldom, yeah. So.
And regarding Jim and Chris, is there any doubt in your mind that Jim cares for his sister Chris and that she cares for him?
No, I think they've certainly never been estranged or not liking each other, and they've always been pretty close.
And although their paths have sort of gone in different directions. That's all I have, Mr. Holmes. Thank you.
So now we have replayed both of the parents, Robert Holmes and Arlene Holmes. Those, of course, were key pieces of testimony here during phase 2 of this trial. Of course, phase 2 is about mitigating factors or circumstances, situations that, while they're not excuses for the crime, they do speak in favor of a lenient sentence or a more lenient sentence. Of course, the two choices on the table are life in prison without the possibility of parole and the death penalty. But of course, the death penalty would require us to go through at least, through one more step of this process, the third and final phase. We'll see that all of the jurors need to agree unanimously, but not necessarily for the same reasons, that we should be progressing on to phase 3, that the aggravating circumstances are not outweighed by the mitigating circumstances. Language that mitigating factors do not outweigh the aggravating factors. It's sort of an opposite way of thinking than the way that we've been saying it aloud and verbalizing it for the last several days of coverage. Of course, I should say this is the 60th day of our coverage of the Aurora Movie Theater Shooting trial. And of course, here, the other option is that if any one of them dissents, the case can end and the case and the gunman would be sentenced to life in prison. They have not yet had the question actually face them, the question of the death penalty. But if they decide to move forward, if all 12 jurors sign, the 9 women and 3 men, and sign on these lines, then we would move forward to phase 3, where we would hear from the victims or families of victims, and the jury would then be asked to deliberate for a 4th and final time at the conclusion of phase 3, where they would be asked to decide between life in prison or the death penalty. Of course, mental health is a key factor in the case, and it was a cornerstone. The jury rejected mental health during the guilt phase. They said no to the not guilty by reason of insanity plea. They found him guilty on 165 counts. At this point, though, mental health is again a centerpiece of the 6 various factors under Colorado law that the defense said are mitigating factors that are present in this case, and the 62 points that the defense told in their theory of mitigation. Without a doubt, the strongest overall theme was mental health. Of course, one way of breaking down this question, boiling it down now, is if that is the centerpiece of their case, is mental health a sufficient reason for this jury to spare someone's life, or for even one juror to spare this gunman's life? Only 12 minutes left. We're going to replay some of that. This is a woman who's been hounding the case all the way back through 2013 when she actually filed legal documents, and I don't have the documents themselves. They haven't been released to me. But I do have records that she did file legal briefing in May of 13 and was denied a few days later. She showed up in court and had been attending court for several days before the outburst that interrupted George Brockler's closing argument, and we'll recap some of that now for you. Of course, court is supposed to resume at 12:30. As soon as court does resume, we will interrupt this playback and go live for the reading of the verdict.
All right, please be seated, everyone. Mr. Brockler, you may proceed.
Thank you, Your Honor. What the instruction tells you for statutory mitigation is the issue is...
Your Honor, you mentioned a disruption, and I know I was reading the transcript that the court reporter put a brief mention in there that there was a disruption or something in the gallery. But I think we just need to make a record of what happened. And one thing I'm going to do, if it's okay with the court, is I know there's a TV feed for the courtroom not showing the gallery, but you can hear what's going on in the courtroom pretty clearly, and she was screaming pretty loud. And I imagine Mr. Brockler's microphone might have picked it up, or some other microphone. So I'm going to see if I can actually get a record of that, and hopefully we can make that a court exhibit. And I'm going to try to do that, if that's okay with the court.
Is that okay with the defense? Yeah, that's fine with me as well. You said transcript. I think you meant real time.
The real-time transcript, that's correct.
It's not a transcript. It's just real time. There is no transcript. You're looking at the real time on the screen on your computer. You have to be accurate on these things. So it's not a transcript. I know what you mean, but for the record, you're referring to the real time on your computer, correct?
I'm referring to the real-time that's on the small computer that is placed on our table that is provided by the courts. Yes,
Okay,
ma'am.
great, thank you. All right, and for the record, this was a woman who has indicated to the sheriff's department that she is homeless. The sheriff has had some concerns about her, but she promised to behave in the courtroom, and this is a public courtroom. She's been here for the last handful of days and has been complying with all of my orders that relate to people's behavior in the courtroom and to the decorum that has to be observed in court. So we had no basis to exclude her from the courtroom. It's a public courtroom, and but it's someone that we were aware of. I think the parties may have been aware of her as well. And she's obviously not going to be allowed in the courtroom for any future proceedings in this case. Do the parties have any position with respect to whether I conduct any other types of proceedings with respect to her?
Well, Your Honor, you're the court, and that was certainly contemptuous. I don't believe I've ever actually, and I've been a lawyer since 1991, and I've appeared in courts all over this state and in Maryland as well, and I've seen lots of contemptuous behavior directed towards the court. I have never seen behavior that contemptuous towards the court, towards the dignity of the court, towards the sanctity of the proceedings. It is, as we say in the law, direct contempt, because Your Honor witnessed it. It happened in the courtroom. Have a hearing and find her in contempt of court and treat her accordingly. That's my position.
All right. I know that she's currently being detained until I decide what to do. So, Ms. Brady, anything from you?
Your Honor, I think she's obviously mentally ill. I don't think holding her in contempt is going to help with that. And, I mean, perhaps see if the county attorney wants to check into maybe she needs some psychiatric help. We've all discussed how there's a statute where you can hospitalize someone you feel is mentally ill. Perhaps that would be the more humane approach to this.
Well, I'm not going to assume that she's mentally ill. I don't know whether she is or she's not. I know that the sheriff was concerned about her for different reasons, but I also know that the sheriff was very clear with her about the rules when you're in the courtroom, and I know that she's been following those rules for the past 5 days, and she chose not to do so today. So that's what I know. In terms of whether she's mentally ill or not, I'm not going to make any assumptions. Mr. Bruckler?
Your Honor, I only ask if the court would permit me to just supplement the record from my vantage point with the jury. Clearly, the outburst distracted the jurors and interrupted the closing statement. And I appreciate the court giving me a little extra time. When I started back up, I could tell, even because of the noise coming in from the outside, there were still numerous jurors that were not tracking the closing. They were looking towards the door where this outrageous act had taken place. And I appreciate the court giving me time, but I do think the record should reflect that for a couple minutes, at least in the middle there, several of the jurors seemed unfocused because of this incident.
All right, thank you. Is there any CAVE as a result of a disruption that Ms. Cave made during the closing argument in phase 2 of the sentencing hearing in the case of People of the State of Colorado versus James Egan Holmes, case number 12 CR 1522, and specifically it was during Mr. Brockler's closing argument. Rule 107 of the Colorado Rules of Civil Procedure defines contempt as follows in subsection A1. Disorderly or disruptive behavior, a breach of the peace, boisterous conduct, or violent disturbance toward the court, or conduct that unreasonably interrupts the due course of judicial proceedings. Behavior that obstructs the administration of justice, disobedience, or resistance by any person to or interference with any lawful writ, process, or order of the court, or any other act or omission designed as contempt by the statutes or these rules. Subsection B of the same rule defines subsection A2 defines direct contempt as follows: contempt that the court has seen or heard and is so extreme that no warning is necessary, or that has been repeated despite the court's warning to do it. Reciting the facts constituting the contempt, including a description of the person's conduct, a finding that the conduct was so extreme that no warning was necessary, or the person's conduct was repeated after the court's warning to desist, and a finding that the conduct is offensive to the authority and dignity of the court. Prior to the imposition of sanctions, the person shall have the right to make a statement in mitigation. In the case of in re marriage of Sir and K, and that's CYR, 186 Pacific 3rd, 88, a Colorado Court of Appeals case from 2008, the court spoke as follows. Rule 107 of the Colorado Rules of Civil Procedure distinguishes between two types of contempt, direct and indirect, and defines the actions constituting contempt to include disobedience by any person to any lawful order of the court. Thus, to find a party in contempt, the fact finder must find that the contemner did not comply with a lawful order of the court. The duty to comply arises because the contemner was aware of the order. Punitive sanctions are criminal in nature and are designed to punish by unconditional fine, fixed sentence of imprisonment.
Ladies and gentlemen, the court is in session, and we are going to take you there live right away.
Let me give the advisement that I have given in the past, and that is to the members in the gallery, the folks sitting in the gallery. Before we bring the jury in, I want to address all of you spectators in the courtroom. This is a public trial, and I want everyone to feel welcome and comfortable here. That is important to me. However, you must observe proper courtroom decorum. I am sensitive to the fact that this case may evoke powerful emotions. I fully understand that. For that reason, I have not prohibited emotional reactions. To the contrary, in Order D79, I recognize that any time you feel the onset of an emotional outburst, please quietly and discreetly exit the courtroom. You may return to the courtroom when you're ready to do so in compliance with my order. In general, for the most part, so far in this trial, there have been almost no issues. There was one last week. That one aside, there have been no issues from anyone in the gallery, and I thank you for that, and I ask that you please continue to conduct yourselves as you've done throughout the trial. Please remember that it is my duty and responsibility to ensure that both sides receive a fair trial and to uphold the dignity of the court. With that announcement, are the parties ready for the jury? Mr. Brockler.
We are, sir.
Ms. Brady. Yes, sir. Let's bring the jury in, please, with the alternates first. And let's bring the deliberating jurors in next, please. Please be seated, everyone. The record should reflect that all of the jurors are now present in the courtroom. Mr. Foreperson, it's my understanding that the jury has reached sentencing verdicts in phase 2 of the sentencing hearing on all the counts. Is that correct?
That's correct.
All right, would you please tender the verdict forms to my staff? Thank you. Those of you who are in the gallery, I ask that if you're here when I read the first verdict form, that you stay here for the reading of all the verdict forms. If anybody cannot do that, now would be the time for you to leave. So I'll give you a moment to leave if there's anybody who cannot do that in the gallery. All right, would the defendant please stand for the reading of the Phase 2 sentencing verdicts? Phase 2 sentencing verdict form, count 1. Murder in the first degree after deliberation, Jonathan Blanc. The Phase 2 sentencing verdict question reads as follows. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing? And the instructions read as follows. If the answer to the Phase 2 sentencing verdict question is yes, the foreperson shall sign on the designated line in Section 1, and the rest of the jurors shall sign on the other lines in Section 1. In that event, the sentencing hearing will continue to Phase 3 on this count. Only one section, Section 1 or Section 2, shall be completed. If the answer to the Phase 2 sentencing verdict question is no, the foreperson shall sign on the designated line in Section 2. In that event, the sentencing hearing will end with respect to this count, and based solely on the jury's Phase 2 sentencing verdict, the defendant will be sentenced to life imprisonment without the possibility of parole on this count. Only one section, Section 1 or Section 2, shall be completed. On the Phase 2 sentencing verdict form for count 1, the question, does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing, is answered yes. And the foreperson has signed in Section 1, and all the other members of the jury have signed as well. Phase 2 sentencing verdict form, count 2, murder in the first degree. The jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing. The answer is yes, and all of the jurors have signed reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing. The answer is yes. All of the jurors have signed Section 1 of the verdict form. Phase 2 sentencing verdict form, Count 5, murder in the first degree after deliberation, Jessica Gowie. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The answer is yes, and all of the jurors have filled out section 1 of the verdict form. Phase 2 sentencing verdict form, count 6, murder in the first degree after deliberation, John Larimer. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. The answer is yes, and all of the jurors have signed section 1 of in phase 1 of the sentencing hearing. The answer is yes, and all of the jurors signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 10, murder in the first degree after deliberation, Alex Sullivan. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The answer is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 11, murder in the first degree after deliberation, Alexander Teves. Does the jury unanimously find beyond a reasonable doubt that verdict form for count 12, murder in the first degree after deliberation, Rebecca Wingo? Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The jury's answer is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 13, murder in the first degree extreme indifference, Jonathan Blanc. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The jury's answer is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 14, murder in the first degree extreme indifference, Alexander Boyk. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase? Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The jury's answer is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 16, murder in the first degree extreme indifference, Gordon Cowden. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 17, murder in the first degree extreme indifference, Jessica Gowie. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 18, murder in the first degree extreme indifference, John Larimer. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 19, murder in the first degree extreme indifference, Matthew McQuinn. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase one of the sentencing hearing, the answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 21, murder in the first degree extreme indifference, Veronica Mosher Sullivan. Does the jury unanimously find, beyond a reasonable doubt, that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in murder in the first degree extreme indifference, Alex Sullivan? Does the jury unanimously find, beyond a reasonable doubt, that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. Count 23, and the phase 2 sentencing verdict form for that count, which is murder in the first degree extreme indifference, the answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 24, murder in the first degree extreme indifference, Rebecca Wingo. Does the jury unanimously find, beyond a reasonable doubt, that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The answer from the jury is yes, and all of the jury phase 2 sentencing verdict forms for counts 1 and 2 has been crossed out with an X, and the foreperson appears to have signed each form, actually each page of each form, in the right top hand corner of each page. Are the people requesting that I poll the jury, Mr. Brockler?
No, Your Honor, thank you.
Is the defense requesting that I poll the jury, Ms. Brady? Okay, I will do so. Members of the jury, I've explained to you that each party has an opportunity to request that I poll the jury. That simply means that I ask each of the deliberating jurors individually, are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts? Seat number 2, juror 17. Are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts?
Yes, Your Honor.
Seat number 3, juror 329. Are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts?
Yes, sir.
Seat number 5, juror 535. Are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts?
Yes, Your Honor.
Seat number 6, juror 87. Are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts? Seat number 11, juror 118. Are these your phase 2 sentencing verdicts and the jurors' phase 2 sentencing verdicts?
Yes, sir.
Seat number 13, verdicts and the jury's phase 2 sentencing verdicts?
Yes, sir.
Seat number 15, juror 527. Are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts?
Yes, sir.
Seat number 17, but temporarily sitting in seat number 18, and that's juror number 737, the foreperson. Are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts?
Yes, sir.
Seat number 21, juror 557. Are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts?
Yes.
Seat number 23, juror number 311. Are these your phase 2 sentencing verdicts and the jury's phase 2 sentencing verdicts?
Yes.
Thank you. Members of the jury, what I'm going to do at this time, given that it's 5 till 1, is go ahead and release you with the same admonishments that I have been giving you throughout the trial. Not the admonishments that apply during deliberations, but the ones that apply when you're not in deliberations, and that's when the deliberating jurors are not in deliberations. All of those admonishments are extremely important, and you need to make sure that you comply with each and every one of them. I'm gonna have you come back tomorrow morning at 10, so you can sleep in a little bit, okay? And that'll give me time to do work with the attorneys before you get here. We'll also try to see if we can get some work done this afternoon as well. Let me go through the advisements just to make sure that you're all clear on them. They're all extremely important, and I can't emphasize enough how important it is that you follow each and every one of them. I also can't emphasize enough that you avoid an attitude of nobody's going to find out if I just violate one of these once or maybe a couple of these once or twice. You have to avoid the temptation to think along those terms. We're relying on you to follow each and every one of these advisements. Each and every one of these advisements is mandatory. Number one, please do not discuss any aspect of the case with each other through any means. You're free to talk to one another, but not about the case. You can even talk with each other if one of you is a deliberating juror and another one of you is an alternate juror, but you cannot talk about the case. You cannot talk about the case with any other juror. Number two, in addition to not being able to discuss the case with each other, you may not communicate about the case with anyone else through any means. That includes your spouse or significant other. All you can tell people is that you're on a juror in a proceeding in Arapahoe County that is expected to end at the latest at the end of August. You may not have any contact or communication with any jurors who have been dismissed. Please do not talk with any witnesses, parties, or attorneys about anything, whether related to the case or not. That was number 4. Number 5, to make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you're on the courthouse premises and that it is visible to everyone around you. If you hear something about the case, please let my staff know that you need to talk to me about something. Number 6, please do not talk to any members of the media about anything. Number 7, you must not read, view, or listen to any news or media reports that may refer to this case or to any case like this case. Because there's media coverage of this case, please be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any electronic device. 7B is one admonishment that I added last week, and that is you must avoid all news reports and all media reports of the event in Louisiana. Number 8, you cannot visit any locations mentioned in the case or conduct your own investigation outside the courtroom. Number 9, please keep in mind that your sentencing verdicts in this case must be based solely on the evidence and information presented in the courtroom and the instructions of law that I provide to you. Number 10, as you know, based on your verdicts, the next phase is going to be phase 3. You cannot start forming any opinions about the case until I tell you that you can start deliberating. You must keep an open mind throughout phase 3. And lastly, please remember that the attorneys have a job to do. They're required to make objections. Sometimes they're required to ask to approach or to request a bench conference. That they do that. They're doing their job. To the extent that we ever have delays, do not hold it against either side that happens. If you need to hold it against someone, hold it against me. Do not hold it against them. They have a job to do. They're doing their job. And finally, please remember that I'm neutral in these proceedings, and so do not read or anything into my rulings or infer anything from my rulings in terms of me being for one side or the other or having any opinions or feelings about the proceedings. I am neutral, and I am simply doing my best to apply the rules of evidence and other applicable rules of law. Does everyone understand all of that? And everyone's nodding their head yes and saying yes. Is there anything else on behalf of the people before I release the jurors until tomorrow morning at 10?
No, Your Honor, thank you.
Is there anything on behalf of the defense before I release the jurors until tomorrow morning at 10? Okay. Thank you, folks. I'll see you tomorrow morning at 10 o'clock. Get some rest tonight. Thank you. Please be seated, everyone. The record should reflect that the jury has left the courtroom now. that's not only the deliberating jurors, but the alternate jurors as well. What I propose, you've had an opportunity to review those, have me come out and have a discussion about them so we can finalize them, and then we can start tomorrow at 10 o'clock. Does that make sense?
Yes, sir.
Does that make sense to the defense? Okay. And Ms. Tish McGuire, I know that you filed an updated, I think it's P83. There are a couple of things in there that I need to address as well, a few things in there that I need to address. And so that's why I had the jury come in at 10 in case we're still doing that tomorrow morning. But I'm going to try to see if I can get through all of that today during the break, and then we can talk about it tonight if we have time, okay? Does anybody have anything at this time that we need to talk about before I take a break?
No, Your Honor, thank you.
Anything for the defense before I take a break, Ms. Nelson?
How long of a break will you?
I'll give you as long as you need.
Okay.
So I'll give you an opportunity to review the introductory instructions. I reviewed your tendered introductory instructions and the people's tendered introduction. How long do the people anticipate phase 3 will take?
2 to 3 days, Your Honor.
Okay, does the defense anticipate at this time putting on any evidence in phase 3? And if so, how long do you anticipate that will take? Okay, all right, great. The court will be in recess. Thanks, everyone.
Please rise.
So we are moving on to phase 3, a phase that is expected to take 2 or 3 days, if you heard the District Attorney George Brockler right there telling the court. What we expect phase 3 to include is the family members of the phase 3 in my understanding. While I sit here, let me ask Erica a question. Erica, would you find out if Rick is available to talk to us about this subject? Our legal analyst, Rick Kornfeld, I know he was watching, and we'll try to get him on the line right now to explain that in greater detail, certainly his expert detail for us. But phase 3, my understanding, is only a couple of days to hear statements from those who knew the 12 who were killed, of course. So, Rick, let's start out with talking about phase 3. Give us the textbook definition and what we should expect, please.
Well, phase 3, this is the textbook, not the technical legal definition. Phase 3 is really the kitchen sink phase of the penalty process. Basically, it's not really a legal determination at this point. I mean, ultimately it's a legal determination, but it is based on the jury deciding whether or not to give the death penalty, and they can take into consideration the effect that the victims' deaths have had on the victims' families, the manner of their death. They can basically take into account everything and anything, both what they've heard already, and then they're going to hear some new information, which is how this crime has affected the victims. So on the one hand, that is classic victims type testimony, and under the Colorado Victim Rights Act, that is the sentencing determiner, which in this case is the jury, gets to hear that in every single criminal case in Colorado. On the other hand, in a death penalty case, and in this case it's vitally important because these are things that while the jury's heard a lot about the victims, now they're going to hear how this crime has affected the family. So it's going to be, if it's even possible, it's going to be even more emotional. On the defense side, they're going to throw in whatever not so much whatever other evidence, because I think they've pretty much heard all the evidence, but essentially you are getting up and you are begging for the life of your client. That is what you're doing. You are begging for mercy. And I've been in that position. When I did it, the process was a little bit different, but make no mistake, and I told the jury when I did it, I am up here begging for the life of another human being. And I will tell you something, we lawyers are not trained to do that in law school, or at least in my case, anywhere else. So it's going to be gut-wrenching, it's going to be emotional, and it is going to be extremely intense. And we've seen the preview of the arguments in Phase 2 from both sides.
let me ask you this, just to be 100% clear, the statements that we've heard about or heard referenced from the people who survived being injured and wounded in the shooting, that comes after a verdict either direction, whether it's life in prison or death penalty. That's not the people who are tied to the 12 who were killed, but the people who have other counts listed in their own names. Those people have the opportunity to make a statement after a decision is reached, but before he's sent off. Is that right?
Yes, that is exactly right. Those statements are pertinent to the sentence, just like in any other case. But what's at issue in Phase 3 is testimony regarding the deceased victim. So you are exactly right. Those folks will have their opportunity to be heard as well. But frankly, I think the opportunity, and not to diminish that, the opportunity to be heard is important. But frankly, the Phase 3, he's either going to be condemned to die under the Colorado death penalty statute, or he's going to be given life without possibility of parole. That's the only other alternative. And it is not going to matter what the other living victims say. It's not going to matter in the sense that it will not be a determining factor in the sentencing. Only Phase 3 will really determine the ultimate sentence as it pertains to the most serious crimes, which of course were the murder convictions.
When you had the opportunity to go through something like this process, I realize it was a little bit different. It must have been very difficult to decide what questions to ask of the families of those who were killed, those who were lost in the crime. Can you imagine, in this case, will the defense be cross-examining these family members?
I don't think so. I would be surprised. I mean, what possible benefit could that have? And you run the risk of simply having the witnesses reinforce what they've already said on direct. I think it will be. You're going to see not that the other phases of the trial haven't been hushed and serious and respectful. This is going to be funereal. I mean, this is going to be as serious a proceeding as there can be in a court of law in the United States. And so I would be very, very surprised if the defense asks a single question of these witnesses, because they have nothing to gain. And as a courtroom lawyer, everything you do or you don't do in a courtroom, you do, or in this case, don't do for a purpose. So unless you think you can accomplish something, you don't ask a question, and I just cannot imagine what any experienced lawyer would think that he or she could accomplish by cross-examining somebody at this stage.
Do you suspect, do you suspect that there's anything we can infer from how fast the Phase 2 verdict came down? We looked at it earlier. It was something like 13 hours for decide if he would.
But I'll tell you what, if I were on the defense side, if I were the Holmes family, if I were James Holmes, I would be plenty darn worried right now, because essentially, let's go back to what the quote-unquote defense is. First, there was the legal defense, his mental state, and that was firmly and summarily rejected. Then there was the Phase 2, which is take into account the mental state not as a legal defense for his actions, but essentially as a mitigating factor. And it was summarily rejected in a pretty short amount of time, in my opinion. So I don't think that bodes real well. You have to step back and remember, these are what are called death if you are on the James Holmes defense team. And you've got 12 people who have said, I could give the death penalty if the facts and circumstances warrant it. Well, now you're back to this argument, can you imagine a case that could be any or much worse than this one, that would merit the death penalty. So we're reading tea leaves here, but the bottom line is I do read into and how it becomes a mitigating factor in phase 3 is extremely challenging as a defense lawyer. And what you have to do is through emotional appeals and through the begging, really the begging for.
I have a question for you from one of our viewers. The DA said this is going to take 2 or 3 days for his list of witnesses, and we don't know yet if the defense is going to call any. That's still up in the air. If they do, or if either side with their witnesses, is there any time limit, anything like that, that limits how long they can speak about the loved ones that they lost for the prosecution?
Well, I mean, by rule, there are no time limits, and I'm not aware of any time limits that Judge Samore has imposed on these types of statements. Judges are incredibly solicitous of crime victims in any case, and especially in a murder case, and especially in a murder case of this magnitude. So I would be very, very surprised if Judge Samore limits the attorneys or limits the witnesses, or if there are any interruptions, or even if there are a lot of objections about cumulative or anything else. That being said, I think that if you're the prosecution and you're putting these witnesses on, you again, everything you do in a courtroom is for a purpose, and oftentimes less is more, through kind of not a very succinct presentation. So I would think that even though it's going to take a while, I would think that, if you're the prosecution, you are preparing these witnesses like you would prepare any other witness. You want to put on a clear, clean, directed examination. It will be emotional. I mean, that goes without saying. But I don't see Judge Samore staring at his watch. And all that being said, also don't forget, we're way ahead of schedule. This case is going to finish, no question, before the month of August is out, and that was sort of the original time frame. So that's the other thing the judge doesn't have to care about. But even if he were running a few weeks late, I don't think he's putting the brakes on any of these victim witnesses.
Certainly true that we are ahead of schedule. The prosecution is going to be finished now before the end of the week, if their time estimate is right. We're still waiting to find out if the defense is going to call anyone. They said they'd get back to the court. What do you think, Rick, and this, I promise, is the last question for you, do you think the defense will call anyone, and if so, what kind of witness might they call in phase 3?
Well, I really don't know. I mean, I don't know who's left. I mean, if we have kitchen sink, if going back to this is the kitchen sink phase, who they've heard from the family, they've heard from the mental health experts. The only other thing I could think of, and this is again just pure speculation, is to put somebody up to talk about essentially what a terrible and rotten existence, spending the rest of your life in a maximum security facility as part of the Colorado penitentiary system, how awful that would be. In essence, arguing, look, if you want to punish this guy, life in prison when you're at the young age that he is would be way worse than the death penalty. I could see them doing something like that, but again, that's just rank speculation on my part. But I guarantee you they are sitting around right now, not that they haven't been thinking about this before, but to the extent that they have a list of people they might be calling or think about calling, they're now revisiting that list in light of lots of factors, including how the evidence has come out so far, how they're reading the jury, what they read into the relatively quick turnaround on the verdict of phase 2, and lots of other factors. But here's the thing, even if they call witnesses, the heart and soul of their presentation is going to be their argument, and again, is going to be their begging, their emotional begging for the life of their client. Because at the end of the day, if you represent an individual in a death penalty case, you have one job and one job only, and that is to do your best, your very best, to save the life of your client. And that's all they are focused on. That's all they've ever been focused on.
All right, Rick Kornfeld, we thank you for joining us at this surprise time of day, but we appreciate it very much that you made the time for us. At this point in time, ladies and gentlemen, we are waiting with no precise time of when court will resume, but court is going to resume. So, what we're going to do at this point in time is replay the verdicts as they were read from Phase 2 just a few minutes ago, and then we're going to put things on pause. We'll put up a message on your screen indicating what time court will resume as soon as we hear from the judge and from his spokesman what time court will resume. In the meantime, of course, we'll still be with you on the chat rooms. We'll still be producing content explaining to you all what happens next in the upcoming portions of this case, Phase 3, and then the final round of deliberations. In the meantime, here are those 24 verdicts again regarding the 12 who were killed, the verdicts from Phase 2.
Would the defendant please stand for the reading of the Phase 2 sentencing verdicts? Phase 2 sentencing verdict form, count 1, murder in the first degree after deliberation, Jonathan Blanc. The Phase 2 sentencing verdict question reads as follows. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing? And the instructions read as follows. If the answer to the Phase 2 sentencing verdict question is yes, the foreperson shall sign on the designated line in Section 1, and the rest of the jurors shall sign on the other lines in Section 1. In that event, the sentencing hearing will continue to Phase 3 on this count. Only one section, Section 1 or Section 2, shall be completed. If the answer to the Phase 2 sentencing verdict question is no, the foreperson shall sign on the designated line in Section 2. In that event, the sentencing hearing will end with respect to this count, and basically is yes, and the foreperson and all the jurors have signed Section 1. Phase 2 sentencing verdict form, count 3, murder in the first degree after deliberation, Jesse Childress. Does the jury? Phase 2 sentencing verdict form, count 4, murder in the first degree after deliberation, Gordon Cowden. Phase 2 sentencing verdict question is, does the jury unanimously find beyond a reasonable doubt that the mitigating verdict form, count 5, murder in the first degree after deliberation, Jessica Gowie? Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing? The answer is yes, and all of the jurors have filled out Section 1 of the verdict form. Phase 2 sentencing verdict form, count 6, murder in the first degree after deliberation, John, in Section 1 of the verdict form. Phase 2 sentencing verdict form, count 7, murder in the first degree after deliberation, Matthew McQuinn. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing? The answer is yes, and all of the jurors have signed Section 1 of the verdict form. Phase 2 sentencing verdict form, count 8, murder in the first degree after deliberation, Michaela Medic. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the first degree after deliberation, Veronica Mosher Sullivan? Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing? The answer is yes, and all of the jurors signed Section 1 of the verdict form. Phase 2 sentencing verdict form, count 10, murder in the first degree after deliberation, Alex Sullivan. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in Phase 1 of the sentencing hearing? The answer is yes, and all of the jurors have signed Section 1 of the verdict form. Phase 2 sentencing verdict form, count 11, murder in the first degree after deliberation, Alexander Teves. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase one of the sentencing hearing? The answer is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form for count 12, murder in the first degree after deliberation, Rebecca Wingo. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The jury's answer is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 13, murder in the first degree extreme indifference, Jonathan Blanc. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The jury's answer is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 14, murder in the first degree extreme indifference, Alexander Boyk. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The jury's answer is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 15, murder in the first degree extreme indifference, Jesse Childress. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The jury's answer is yes, and all of the jurors have signed section 1 of the verdict form. Do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. The answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. The aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. The answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 18, murder in the first degree extreme indifference, John Larimer. Does the jury unanimously find beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing? The answer from the jury is yes, and all of the jurors have signed section 1 of the verdict form. Phase 2 sentencing verdict form, count 19, murder in...
A very hard decision, Bella, to make. I'm a very religious person, and I don't wish death on any person. So even if the jury decides to do life imprisonment or the death penalty phase, I believe I'll be happy with either decision, either way. But knowing for the fact that it's finally over with is my biggest hope for, so I can be able to move on and spend the rest of the time recovering and being with my family.
Josh, when you're in there, your eyes are closed every time he read out one of the decisions in the sentencing. What are you thinking when that happens? Are you praying, or what are you...
I was praying. I'm thinking about each one of the family members. You know, each one of those names that come right up, I kept thinking if it's one of my own, or it could have been myself. That could have had my own name up there. I could have been the one of the 12. And knowing for the fact that there's, you know, brothers and sisters, and be able to see the heartfelt in the parents' faces to know that they had to bury their child is just outright. There's nothing worse than knowing that you had to bury your own child before your own time. I can't imagine what they had to go through, and for such a long period of time, in the past 3 years, you can imagine what they have to go through each and every day. So each time a verdict keeps come through, and every time a name comes up, I have to pray for them. I have to believe that my strength and my praying helps them just as much as it helps me to be able to move forward. And I hope it's the same for them. If you have any more questions, I'd like to go back home to my family now. Thank you. Thank you. First name is spelled Joshua. Last name is Nolan, Nowlan. Thank you, everybody.
Please be seated. Thank you. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with Ms. Brady, Ms. Higgs, and Ms. Nelson, and the people are represented by Mr. Edwards, Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. We are outside the presence of the jury. Let's talk about the Phase 3 introductory instructions first, if we can. And the record should reflect that the prosecution tendered introductory instructions some time ago. The defense submitted them, I think, last week, and I have reviewed both sets. And I have put together my own set based on what the party submitted, and I have had my staff now distribute to both sides a copy of my draft, and we will people had enough time to go through the introductory instructions?
Yes, Your Honor.
Okay, as a defense?
Yes, Your Honor.
All right, thank you. All right, let's go through these. Do the people have any objections or any suggestions with respect to the introductory instructions?
Your Honor, we don't have any objections. I have one question and one suggestion.
Okay.
The question is, should there be a limiting instruction concerning mental condition? That it's only mitigation, rebuttal to mitigation, and is
Final instructions tell the jury that all limitations are gone now, and I think that's an incorrect statement of the law. But I have included an instruction related to evidence that has been admitted for a limited purpose in my final instructions. I don't think that issue is going to come up in this phase, but I'm not sure. But neither side submitted or tendered an instruction related to that. So is the defense asking for one, Ms. Nelson?
In the final instructions, Your Honor, that's our primary concern.
All right, does that take care of the concern on behalf of the people?
that's fine, Judge.
Okay. What else, Mr. Edwards?
The instructions as you are instructed, there are two types of aggravation. It'd read better if it just said aggravating circumstances, so that you have the statutory aggravating factors on one hand and the aggravating circumstances on another. We don't have any objection to the language that is there currently, but that might be a better way to say it.
So take out the non-statutory?
Yes.
The reason I left it in is that's how the Supreme Court talked about it in Dunlap, and that's People versus Dunlap, 975 Pacific 2nd, 723, Colorado Supreme Court, 1999. It's the Dunlap opinion that was authored by Justice Corliss. That's how the court referred to this type of evidence. And the other reason I like it is because it distinguishes it more from statutory aggravating factors. So not only are we changing the word factor, but we're also conveying to the jury that this is not part of the list of factors, aggravating factors listed in the statute. These are non-statutory aggravating circumstances. But what's the defense's position with respect to that request?
Your Honor, we have a very lengthy objection to make regarding this entire instruction. So we object to the jury being instructed on aggravating circumstances in general. And I can explain all of our objections to that instruction now, or wait until we go through them one by one on the defense, from the defense side. But we object to that instruction in general. So.
Okay. All right. Anything else, Mr. Edwards?
No, Your Honor, thank you.
Okay. All right. On behalf of the defense, let's go in the order in which the instructions are.
So with respect to the first instruction, Your Honor, we maintain, again, the arguments that we've made at previous charging conferences regarding the issue of merger.
Do I refer to that issue here? Let me see.
Well, it discusses the the fact that the outcomes of the first two phases of the sentencing hearing do not in any way require you to vote to impose a death sentence on any of the counts of murder in first degree, we maintain that that should be conviction and not counts, and that the counts should have merged into one conviction for each victim.
Okay, I incorporate by reference my rulings and comments with respect to that issue. What else?
And then the second request that we have with respect to that first instruction is to include a sentence at the end of the first paragraph that reads, under the law, a life sentence is always an appropriate and acceptable verdict. So that would come immediately after a death sentence is still never mandatory or required by law. We think a sentence conveying that message or sentiment to the jury is required by the Eighth Amendment, as well as Article 2, Section 20 of the Colorado Constitution, as well as the state and federal due process clauses of those respective constitutions, to make it clear to the jury that a life sentence is always an appropriate and adequate verdict for them to render.
Mr. Edwards?
Your Honor, it's our position that that paragraph that ends the death sentence is still never mandatory or required by law sufficient.
And what's your specific position on the request to add that sentence that was just read by Ms. Nelson?
We object to it. Thinks it's redundant of the sentence before.
I don't think it adds anything, and the other issue that I have with it is that if the jury follows the court's instructions, a death sentence is also appropriate, depending on how they vote. If they follow my instructions, which say it has to be unanimous and it has to be beyond a reasonable doubt. If they are all unanimously convinced beyond a reasonable doubt that death is an appropriate sentence, then death is an appropriate sentence, and the law would recognize that. So I have to be careful when I instruct a jury on the law to be neutral and not to convey to them that somehow I have a position on this. I don't. I can't have a position on this, and so I don't think it's I don't think it's helpful. Number one, and number two, I don't think that that's the only adequate or acceptable sentence that there can be, assuming that the jury follows my instructions. So that request is denied. Should we move on to the second instruction, Ms. Nelson?
Yes, Your Honor.
Okay. What about with respect to the second instruction, which starts out with, in phase 3 of the sentencing hearing?
Our first request, and this is a global request, that each time the jury is being told, each of you will be asked to individually decide whether or not you are convinced beyond a reasonable doubt that death is the appropriate sentence. It should read that death is the only appropriate sentence. Our position is that the Eighth Amendment, as well as Article 2, Section 20 of the Colorado Constitution, and the heightened standards of reliability required in capital sentencing proceedings, require that it be the only appropriate sentence before a jury can impose the death penalty.
All right, Mr. Edwards, and if you would, I'm being told that apparently they can't hear you, so if you would speak right into the microphone, please, or switch to a different mic.
We would object to that as well. The statute says appropriate sentence. This is a phase where the jury determines an appropriate sentence.
I agree. That's what the statute says. That's what the law says. It doesn't say only the only appropriate sentence. It says the appropriate sentence. So I'm going to stick with the way the instruction reads in that regard. Do you have anything else with respect to this particular instruction, Ms. Nelson?
We do, Your Honor. Our next objection pertains to some issues that we've discussed at previous charging conferences regarding the following sentences. The exercise of your individual reasoned moral judgment must be based on the evidence and information presented during the trial and sentencing hearing. Each juror may consider mercy for the defendant, but mercy must be based on the evidence and information presented during the trial and sentencing hearing. We maintain our objections to those sentences pursuant to the objections that we made at previous charging conferences, that the individual reasoned moral judgment as well as mercy need not be based on the evidence and information presented. And we would also request that the court instruct the jury that mercy alone can be a sufficient basis for a life sentence or a reason not to impose a death sentence, and cite to People versus Davis, Gregg versus Georgia, and Barnes versus State, which is the Georgia Supreme Court case that I cited at the most recent charging conference that we had.
Mr. Edwards?
Your Honor, this argument has maybe been made before, and we would just stand on our arguments that we've made before.
What about the last part of the request, which is to inform the jury that mercy alone can be a sufficient basis for a life sentence or a reason not to impose a death sentence?
I'm not sure that's necessary. The jury has determined an appropriate sentence based upon all the factors, the aggravating circumstances, and the mitigation.
I don't think the jury can exercise, or that each juror can exercise his or her individual reasonable moral judgment in a vacuum, separate from and independent of the evidence presented and the information presented here and the instructions of law that I provide. So it has to be, both of those concepts have to be anchored in the evidence presented and in the information presented, as well as my instructions of law, but specifically the evidence and information presented during the proceedings. So I incorporate by reference my rulings and comments with respect to that issue. In terms of the request, the last part of the request, to tell the jury that mercy alone can suffice for a life sentence, or for a decision that a death sentence is not appropriate. What I believe the law says is that each juror can consider mercy in making their decision. So as each juror exercises his or her reasoned moral judgment, each juror can consider mercy, and it's not up to the court to tell the jurors whether how much to consider mercy, whether a little, as long as it is based on the evidence and the facts presented in the proceedings. And I think the rest of that, in terms of the request, it may be appropriate for closing argument, but I don't believe that
To that mercy issue, the court doesn't find is not inclined to give the sentence or add the sentence that I proposed. We're just going to brainstorm a little bit and see if we have an alternative that might be acceptable to the court. Our next request would be to add each of the jury's final sentencing verdicts must reflect a profoundly reasoned moral response to the defendant's background, character, history, mental illness, and crimes. That goes along with the way that jurors were instructed on mitigation. In phase 2, I believe that mental illness or mental health was specifically mentioned in the definition of mitigation.
Mr. Edwards?
How do we object that? The statute in the United States Supreme Court case law says it's to be based upon the defendant's background, character, history.
This is what the case law says, and so I'm going to stick with it. In terms of mental illness, I think it would be improper for the question. In terms of the crimes, I don't think I need to specify here that we're only talking about the crimes of first-degree murder, but I'm happy to do that if you want me to. I think it's clear to the jury that that's all we're dealing with, and I think I specified that.
We would ask that the court specify crimes of murder in the first degree.
All right, I'll do that. Okay, anything else with respect to this particular instruction, Ms. Nelson?
Yes.
Same objection as before, same ruling as before.
And then
In terms of the word only, I don't think that's the law, and so I don't think it's appropriate to add the word only as in the only appropriate sentence. Go ahead.
Edit and seems to suggest some sort of unanimity requirement in the other direction. We would ask the court to rephrase it. If any one juror is not convinced beyond a reasonable doubt, or perhaps if one or more jurors are not convinced beyond a reasonable doubt.
Any objection from the people?
No, Your Honor.
All right, I'll change it. I think that's fair. I'll say if one or more jurors are not unanimously convinced beyond a reasonable doubt that death is the appropriate sentence, the defendant will be sentenced to life imprisonment without the possibility of parole.
I would actually take out the word unanimously, because I
Okay.
don't think it makes sense in that context.
You're right. If one or more jurors are not convinced beyond a reasonable doubt that death is the appropriate sentence, the defendant will be sentenced to life imprisonment without the possibility of parole. Is that
Yes.
better? Okay, great.
Yes, and then again, in the last sentence, maintain our position that should read only appropriate sentence.
Same objection as before, same ruling as before with respect to the word only as it relates to the appropriate sentence, and specifically the potential sentence of death. The next instruction,
We have nothing on that third instruction.
okay? And that's the instruction, by the way, for the record, that starts with the defendant may present evidence and information in phase 3, and then he goes on from there. Just so that the record is clear, the first instruction started out with members of the jury, it now becomes your duty to determine the appropriate punishment or sentence, and it goes on from there. The second instruction that we talked about starts out with, in phase 3 of the sentencing hearing, there may be additional evidence presented by the prosecution and the defense. As I indicated a moment ago, the third instruction starts with, the defendant may present evidence and information in phase 3 of the sentencing hearing on his own behalf, and then he goes from there. And now we're at the fourth introductory instruction, which starts with, in phase 3 of the sentencing hearing, there is no burden of proof. Ms. Nelson?
Your Honor, we do have a suggestion on the mercy issue in instruction 2. We can go back to that now, or I can move on to instruction number 4, and we can go back to it at the end.
Let's
whatever
go
the
back
court-
to it now.
Okay. Our proposal would be to add a sentence at the end of the sentence that currently discusses mercy, that reads, each juror may decide for himself or herself the role that mercy plays.
Well, I think to have it be completely accurate, it would have to read, each juror may decide for himself or herself the role, if any, mercy plays in determining the appropriate sentence, because the jury is not required to consider mercy. The jury may consider mercy if it wishes to.
In that case, we would withdraw our suggestion and request.
All right, let me ask the people, do they have any response on this in terms of the initial request or what the court suggested a moment ago?
If anything's going to be added, we agree with the court's suggestion.
Okay, all right. Well, I'm happy to add it the way I said it or something along those lines, but I think the way that it was requested, it is not consistent with the law. All right, so we move on then to the next instruction, which is number 4. And this is the one, again, that discusses in the first line that there is no burden of proof. Ms. Nelson?
Thank you, Your Honor. And just with respect to that last issue, we maintain our request that the court give it as we requested.
Right, and that request is denied. I'm happy to give it, as I said, by adding if any, because I think otherwise it conveys to the jury that they're required to exercise or to consider mercy, and they're not. They may, but they're not. So, all right, with respect to the fourth instruction.
So with respect to the fourth instruction, first we maintain the position and the objections that we've made in motions D 146 and 147, that the prosecution should bear the burden of proof and persuasion at this phase of the sentencing hearing.
Okay, I incorporate by reference my orders D 146 and D 147 rejecting that argument.
Second request, Your Honor, is with respect to the second paragraph. The second sentence currently reads, a juror may not determine that a death sentence is appropriate unless he or she is convinced beyond a reasonable doubt that death is the appropriate sentence. And we would propose changing it to read, a juror may not vote to impose the death penalty unless he or she is convinced beyond a reasonable doubt that death is the only appropriate sentence. So it's changing may not determine that a death sentence is appropriate to vote to impose the death penalty.
And the reason why I have it the way I have it is for consistency's sake. Throughout the introductory, we'll end up asking the jurors. But do the people have any say on this, Mr. Edwards?
Yes, Your Honor, we object to the defendant's proposal. We prefer what the court said is determined, especially based on the fact that it has to be based upon individual reason, moral decision-making, and not necessarily a vote. Jurors don't necessarily have to go down there and formally vote when they deliberate.
I think this language that I have in the draft is more specific and it is more accurate, and I believe that it is more consistent with the law, so I'm going to stick with it. So therefore, the request is denied. What else do you have, Ms. Nelson?
Next, we again in that second paragraph, we maintain our position that it should read death as the only appropriate sentence.
Same objection as before, same ruling as before, in terms of the word only before death being the appropriate sentence. What else?
And then finally, Your Honor, with respect to the definition of reasonable doubt contained in this instruction, we maintain and would request that the court omit that last paragraph based on the arguments that we made before, that reasonable doubt in this context and at this phase of the sentencing hearing really does mean a level of moral certainty, and that the description that the court has given in the previous paragraph is sufficient to convey the meaning of reasonable doubt in this context, and that it's confusing to talk about reasonable doubt being based on the evidence. If the court is not inclined to grant that request, however, we would ask, I did notice that it appears that the court has made some changes to that definition,
Right,
breaking
because
things out into the 1, 2, and 3, and we think that it's problematic to change the definition of reasonable doubt at this point in the proceedings when the jury has been given the same consistent definition of reasonable doubt throughout. And so if the court is going to give this instruction, that we ask that it be given in precisely the same language that it was given in previous phases in the case.
Let me just say, under final instructions. Secondly, I changed it in anticipation that the defendant may provide a statement of allocution in phase 3, in which case I would have to include information within this definition. And I think it would make sense to the jury why at that point, and of course the lawyers can talk to the jury about that in closing argument. But given that you're asking me to change it and put it back to the way we had it in phase 2, and given that I don't know what's going to happen yet in phase 3, I don't have a problem either taking it out for now or changing it back to the way we had it in phase 2. Do the people have a preference between those two options? It might be best to just take it out so that if I end up giving this particular modified definition at the end of phase 3, there's not an inconsistency, at least between the introductory phase 3 instruction and the final phase 3 instruction. And I don't think the jury needs it at this point anyway. So, Mr. Right, I don't think you followed me. I'm not considering taking it out of the phase 3 instructions. I'm going to give it to them in the final instructions, either as I've given it to them in the past or modified the way I have it in this draft. My question is not whether I give it to the jury or not in phase 3. The question is, do we need to give it to the jury in the introductory instructions if we're planning on giving it in the final instructions?
And the people's position is that the court does need to include reasonable doubt in this introductory instruction.
In that case, do the people have a position as to whether it should read the same as it read in phase 2 or whether it should read as it reads right now?
We leave that to the discretion of the court.
to instruct.
Your Honor, may I add?
Hold on.
Sure.
Yes, Ms. Nelson?
I just wanted to add that I'm aware that we submitted, and I think it was in our final instructions, the definition of reasonable doubt that we have been submitting throughout, and we did the same in phase 2, and it was after we had submitted phase 2 and phase 3 instructions that in reviewing the instructions, we came to the conclusion that it was a potentially confusing and problematic definition for the decisions that the jurors are tasked with making at phase 2 and phase 3. So I did want to acknowledge that we proposed such an instruction and just state that our position on that had changed.
Okay, thank you. The instruction that I provided in phase 2 is as follows. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the proceedings. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of keep it modified now, or which I don't think is a good idea, because if the defendant does not present a statement of allocution, then the modification would be improper. And the modification, just so that the record is clear, is trial and the sentencing hearing. Number 2, the lack of evidence presented in the trial and the sentencing hearing, or number 3, any other information presented in the sentencing hearing that the court instructs you may be considered. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. And so I don't believe that giving it modified at this time makes sense. And so the question is, do I just delete it altogether, or do I give it the way that we gave it in phase 2, and then if there's a statement of allocution, modify it in the final instructions to include a reference to other information presented in the sentencing hearing? And Ms. Nelson, between those two options, your preference is to take it out altogether. Is that correct?
Yes, sir.
All right, I'll take it out for now. I don't think I need to give it to the jury right now. These are introductory instructions only, and the defense is specifically asking me to take it out, so I'll take it out. All right, the next one is, I think, number 5, the 5th instruction, and these are not numbered, but we're going in order.
Number 4, we still have one more thing.
Okay, go ahead.
The concern that we have with the instructions in general is that the instructions are only affirmatively telling the jury how to get, or under what circumstances they should be returning a death sentence, and how to get to a life sentence is something that's simply implied. And so we would ask that the court add something at the end of the second paragraph that contains affirmative language about how or under what circumstances the jury would reach the point of imposing a life sentence. And specifically, we would request that at the conclusion of the second paragraph, the court add the sentence, moreover, a juror need not be convinced beyond a reasonable doubt that life is the appropriate sentence in order to render a life verdict.
I know I have included language along those lines in the final instructions. I do not have here. And by the way, both of you submitted instructions that, or verdict forms that indicated otherwise. And I think both are wrong. I don't think that the jury needs to be convinced beyond a reasonable doubt to vote for a life sentence. That requirement applies to a death sentence, but the beyond a reasonable doubt certainty, as far as I can tell from the case law, does not apply to a life sentence. So if the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate sentence, they can return a life sentence if they unanimously believe that a life sentence is the appropriate sentence. Of course, if they are not unanimous on that, it's still a life sentence, but then I impose it because they're not able to reach a unanimous verdict. So either way, it ends up in a life sentence. But I don't have a problem adding language that you've requested. Do the people have an objection? I don't know that I will do exactly the language that Ms. Nelson is requesting. Let me see if I can pull out the language I have real quick.
And you're gonna look.
Hold on
okay,
a second.
Sorry.
What I have in the draft final instructions, which I have not yet shared with you, is the following. The degree of certainty defined by beyond a reasonable doubt does not apply to a final sentencing verdict of life imprisonment without the possibility of parole. That degree of certainty is only required for a death sentence. Any reaction to that language, Ms. Nelson?
We prefer our language because I think it's just simpler and a bit clearer. And I was also actually going to impose that perhaps that sentiment would be better placed at the end of the second instruction, after the sentence. If any one juror is not convinced beyond a reasonable doubt that death is the only appropriate sentence, the defendant will be sentenced to life imprisonment without the possibility of parole.
Which instruction are you on?
The second instruction at the very end of that instruction. Or it could go in both places.
And tell me the suggested language again.
A juror need not be convinced beyond a reasonable doubt that life is the appropriate sentence in order to render a sentencing verdict that will result in a life sentence, or simply to render a life verdict.
Do the people have a position on that?
We don't have an objection, Judge. The only objection we have is should be in one place, not in two places.
Right. I can add it. I'm happy to add it to that second instruction. A juror need not be convinced beyond a reasonable doubt to render a sentencing verdict of life imprisonment without the possibility of parole. Is that what you're asking for, Ms. Nelson?
We would ask that it read, a juror need not be convinced beyond a reasonable doubt that life is the appropriate sentence in order to render a decision that will result in a life sentence, perhaps. I think the concern is that they don't actually have to affirmatively choose life in order for a life sentence to be imposed. It's the default. So that's why I was thinking about phrasing the last part of the sentence in the way that I did.
Let's see if I have it right. It would read as follows: a juror need not be convinced beyond a reasonable doubt that life imprisonment without the possibility of parole is the appropriate sentence in order to make a decision that will result in a life sentence without the possibility of parole. Is that good? Yes. And the people don't have any objection, right?
No objection, Judge.
Okay, great. All right, that will be added to the end of instruction number 2.
While we're on instruction number 2, we had another proposal on the mercy language.
Okay.
And that would be: mercy is within your personal individual discretion and judgment. Whether to grant mercy is your decision alone.
What's the people's position?
Your Honor, we object to that. I think that that's fully explained when the court says each juror may consider mercy and proceeds from there. It gives each individual juror the right to consider mercy. So to add an additional sentence is unnecessary.
How about if we added each juror within his or her personal individual discretion and judgment may consider mercy for the defendant, but mercy must be based on the evidence and information presented during the trial and the sentencing hearing.
There's a basis for a life sentence, and ask the court to amend the language accordingly.
All right, well,
that mercy is something that the jurors bring and can exercise outside of the evidence, and that they bring into the courtroom. Their sense of mercy and individual personal moral judgment.
Of course they bring mercy into the courtroom, but they can't make decisions just based on mercy independent of what happened in the courtroom. That's what I keep going back to. Otherwise, again, I don't know why we took so much time in individual voir dire. If the jurors could just decide what sentence is appropriate without regard to the evidence, then why did we take so much time in individual voir dire? And why am I instructing them on aggravators and mitigators? If they can just say, I don't care about any of that, I'm just going to exercise mercy independent of that. I don't think that's how it works. So, all right, I'm happy to modify this the way I indicated, but and frankly, I don't think it adds anything anyway. I think that the point is made in the instruction. The instruction says each juror may consider mercy. That's clear that each juror has the right and the ability to do that, and it's up to them whether they do that or not. So, Ms. Nelson, you would, between the way it is right now and the way that I indicated, I would be willing to change it. What's your preference?
Repeat one more time the proposal.
Yes, each juror may, comma, within his or her personal individual decision. So between
we maintain our position, but between those two options, without waiving any of our positions or arguments or objections, the preference would be to leave it the way that it is.
Okay, got it. Thank you. That's how we'll proceed. All right, let's get to the instruction then on aggravating factors and non-statutory aggravating factors. I think it's instruction number 5 or the 5th in the set. Ms. Nelson.
Your Honor, we have a number of concerns about this instruction. First, we maintain our position that allowing the introduction of non-statutory aggravating evidence during this final phase of the sentencing proceeding violates the state and federal constitutions, the 8th Amendment, and Article 2, Section 20 of the Colorado Constitution, as well as due process clauses of the state and federal constitutions. And I would incorporate by reference all of the arguments that we made in Motion D-144.
All right, I incorporate by reference my order D-144, and also People versus Dunlap requires me to allow this evidence. I mean, it makes it clear that this evidence is admissible in Phase 3, and that is evidence of non-statutory aggravating circumstances. And I use the definition given by the Colorado Supreme Court in that case as to what is non-statutory aggravating circumstances. So this is not within my control as a trial court judge. I have to follow the law, and there is law on point here from the Colorado Supreme Court. So what's your next objection with respect to the instruction?
The second concern, Your Honor, is that at this point, I think the second request we would have is the court not give this in the introductory instructions. Based on the prosecution's sentencing disclosures, Colorado law, victim impact evidence is separate and distinct. It's sort of its own thing. It's not a non-statutory aggravating circumstance in Colorado. Different jurisdictions treat victim impact evidence differently. Some jurisdictions, like I know the federal system treats it as a specifically defines it as a non-statutory aggravating circumstance. In other jurisdictions, like when New Jersey had the death penalty, they discussed victim impact evidence as something that came in as rebuttal to mitigation. Colorado is never defined, and I think purposely so in the way that the statute's laid out, has never defined victim impact evidence as non-statutory aggravation. And so I don't know whether they're planning on introducing any non-statutory aggravating circumstances or non-statutory aggravating evidence. But in the event that they don't, or that they're not, then this instruction, it's not necessary and it wouldn't even apply. And so it may be confusing to give this to the jury in the introductory instructions. And so at a minimum, we would ask the court hold off and we can have another conversation about this after the evidence is presented in Phase 3.
I agree that Colorado doesn't seem to have directly decided the question as to whether victim impact evidence is non-statutory aggravating circumstances evidence or something separate from that, which is why I did not say that in the draft instructions. The draft instructions that I have do not say that victim impact evidence is included within that category of evidence. That's different than the instructions that People tendered. I just couldn't find any case law that addressed it one way or the other. Yours, Ms. Nelson, said that it is not non-statutory aggravation. The People said that it is, and I couldn't find any law on point. And so the question then is, should I take this out because these are introductory instructions and we don't know at this time whether the People are going to introduce any non-statutory aggravating circumstances evidence? What's the People's response?
Judge, just as an example, there is other evidence that has been admitted at trial that can be argued as aggravating circumstances. For example, the statutory aggravator is intentional murder of a child under 12. Having murdered a child under 12 is an aggravating circumstance. So there are aggravating circumstances already present in the crime itself that was introduced during the trial. Or another one is setting up the apartment.
Okay. Ms. Nelson?
Well, and again, if we need to have an argument about that at the final instruction conference, then we can, but if they're not presenting any additional evidence of non-statutory circumstances, then I don't think we need to be injecting this concept in the into the introductory instructions.
Mr. Orman or Ms. Pearson or Ms. Tisch-McGuire, are you intending to introduce any non-statutory aggravating circumstances evidence? And when I ask that question, I'm not referring to any victim impact evidence. And I understand the argument with respect to evidence that has already been admitted at trial, which the jury can consider. I think that's clear. And we can talk about later with respect to the final instructions, how I instruct the jury. But in terms of the introductory instructions, this implies that there is going to be non-statutory aggravating circumstances evidence introduced in phase 3. Are the people intending to do that? In other words, this doesn't tell the jury, hey, well, at least it implies that, and that's the part that is concerning to me. It may be confusing to.
Your Honor, we plan on presenting victim impact evidence, as we've indicated. Our position was and is that is a type of non-statutory aggravating circumstances, but I think I've answered your question.
Okay. Do you have any authority that stands for that proposition? I could not find any, and I looked at Dunlap, and I could not find any there. The court in Dunlap talked about, and again, this is 975 Pacific 2nd, 723. The court talked about non-statutory aggravating circumstances evidence, and about that type of evidence being admissible in phase 3. It also talked in a separate section about victim impact evidence, but it nowhere said whether it is or it's not. And apparently there's a split of authority in other states, although I haven't done the research or complete research in other states or done a sampling of the other jurisdictions. I'm just going off of what Ms. Nelson said, but I couldn't find anything in Colorado that specifically decided that question one way or another.
Your Honor, in the end, I don't think it really matters. I mean, if it's something that the jury can consider, whether we call it victim impact evidence that they can consider, whether we call it part of the totality of the circumstances they can consider, whether we say it fits in the category of non-statutory aggravating circumstances or factors, I don't really think matters all that much as long as the jury can consider it. So maybe that's why they didn't differentiate it. It's all something the jury can consider. I suppose it's possible to say that non-statutory aggravating circumstances is everything other than victim impact that's additional that the jury can consider. I don't really think that makes much of a difference. I've read the case. I understand exactly what Your Honor is saying, but I don't see what else it is other than a non-statutory aggravating circumstance.
And I came to the same conclusion that you did. I don't think it makes much of a difference in the end what category or what label we give it. So for that reason, I avoided either calling it non-statutory aggravating circumstance evidence or calling it not statutory aggravating circumstances evidence, because I thought that was the safer route to go. I'll think about this one. I'm not convinced that we should give it, but I'm not convinced yet that we should take it out either. I have to think more about this one. Anything else, Ms. Nelson, with respect to this instruction?
Yes, Your Honor, if the court is still going to consider giving it. The other concern, we have a couple of other concerns about the instruction. One of them is that at the conclusion of the second paragraph, we have a concern that without another qualifying sentence added on to the end, it's going to suggest that the jury can consider evidence that was offered in mitigation as non-statutory aggravation if they so choose, because it says such evidence may relate to the nature of the crimes of murder in the first degree and the defendant's character, background, and history, which is very similar to the definition of mitigation. So if the court is considering giving the instruction, which again we object to, we would ask the court add none of the evidence, you are reminded that none of the evidence offered in mitigation can be considered by you as aggravation or a reason to impose the death penalty.
Mr. Edwards, any objection to that addition?
Yes, we do, Your Honor. Such evidence offered as mitigation, that's something that the defense does. It's not something the jury finds. So it should be something about, if you found it as mitigation, it can't be used as aggravation.
Didn't we say something about this in the phase 2 instructions? Let me check. It says the court instructs you that you may not in any fashion consider any mitigating factor as an aggravating factor. So what if we did something consistent with that and said you are reminded that you cannot consider any mitigating factor as aggravation or as a reason to impose a death sentence? Mr. Edwards?
Your Honor, our position is this, is that that instruction from phase 2 related to before the jury had made mitigating decisions. They have now made decisions concerning mitigators. And this, well, might be better just to exclude the sentence that says such evidence may relate.
That's another option. Ms. Nelson, does that take care of the issue if I delete that sentence? Such evidence may relate to the nature of the crimes of murder in the first degree and the defendant's character, background, and history?
May I have just a moment, Your Honor?
Yes.
Yes, and again, we object to the instruction as a whole, but we would accept deleting that sentence with respect to this specific issue.
The question then is, does that create a problem because it doesn't provide the jury any more guidance than to say evidence of non-statutory aggravating circumstances is evidence that is unfavorable to the defendant, but which does not relate to a statutory aggravating factor? I mean, I think that the way, based on the statute, the way that Dunlap talked about this, non-statutory aggravating circumstances are things that are not favorable to the defendant, which relate to the defendant's character, background, and history, or the crimes, the defendant's crimes. So it's not, just anything the jury finds unfavorable. So I actually have a concern about that. So back to square one. So the question is how to phrase the sentence that Ms. Nelson is asking for.
Your Honor, perhaps the best option at this point is not to give this instruction.
Okay, the people are agreeing to that? Yes. All right, I won't give it at this time. Great. That makes it easy, and then I'll try to work on some language with respect to that last sentence for purposes of the final instruction in case I end up giving it. All right, the next instruction is number 6, and this one talks about victim impact evidence. You'll notice that it does not identify it as non-statutory aggravating circumstances evidence for the reasons that I stated before. And Ms. Nelson, I included some of the language that you had in your tendered instruction, and then I included some language from the statute as well and from the people's instruction. So, Ms. Nelson, what objections do you have to this particular instruction?
Your Honor, we would propose or object to the two sentences. You may consider this evidence in reaching your final sentencing verdicts. However, the court instructs you that you must not be swayed by emotion, and propose that the court substitute those two sentences with the last sentence of our proposed instruction, which was proposed instruction number 91, which states, however, your consideration must be limited to a moral inquiry into the culpability of the defendant, not an emotional response to the evidence. The concern is that the court hasn't explained how or why or for what purpose the jury can consider this evidence. And really the core of what a capital sentencing proceeding is about is a defendant's moral culpability. And so they can consider this evidence as it relates to their moral inquiry into the culpability of Mr. Holmes, but that is the extent to which they can consider this evidence, and we think that's an important limitation to explain to them.
And I think that rationale comes from, and the language, part of the language actually comes from Cargill versus State, Cargle, 909 Pacific 2nd, 806, which is an Oklahoma Criminal Court of Appeals case from 1995 that Ms. Nelson cited in her tender instruction. This is not the entire instruction that Cargill order should be given. It takes parts from that instruction. Do the people have a position on the request?
We don't have any objection.
Okay, without objection, I will give it. So it'll say you may consider, let me find it. It'll say you may consider this evidence in determining an appropriate.
I think you may consider this evidence in reaching your final sentencing verdicts, period, and then, however, your consideration must be limited to a moral inquiry into the culpability of the defendant, not an emotional response to the evidence.
Okay, so it's the second sentence, that last sentence that you're asking to change.
Yeah.
All right, without objection, I'll change it to, however, your consideration must be limited to a moral inquiry into the culpability of the defendant, not an emotional response to the evidence. And then, do you still want the last part in there? Remember that your final sentencing verdicts must not be influenced by prejudice, bias, passion, sentiment, conjecture, public opinion, or feeling, or any other irrational or arbitrary emotional response. Rather, each of you must make a reasoned moral determination as to the appropriate sentence on each count. Those are the last two sentences of my draft instruction. Are you still asking that I keep those two?
No, Your Honor.
So you want those out then?
Yes.
And do the people have a position on that?
No objection to that. The prejudice, bias, passion statement is repeated in the next instruction anyway.
Okay, I'll take those two sentences out then without objection.
If I may just have a moment to make sure that's our position, Your Honor.
Okay.
That's our position.
Okay, give me a second. All right. Anything on the last, actually not the last one, but the next instruction, Ms. Nelson, this is the one that starts with, in reaching your final sentencing verdicts, you must treat the defendant as a uniquely individual human being, which is, I think, identical to the, or pretty close to identical, not quite identical to the phase 2 instruction that I gave the jury.
We maintain the arguments and objections that we made with respect to the changes that were made to this instruction, to include the prosecution. So wanted to make that record.
Okay, same objection as before, same ruling as before. Without waiving those objections, do you have any changes or suggestions, and would you rather not have this be given in the introductory instructions?
No, Your Honor, our request would be to omit the third sentence. Your decisions in phase 3 of the sentencing hearing may not be the result of mere prejudice, bias, passion, sentiment, conjecture, public opinion, or feeling, or any other irrational or arbitrary emotional response. We think that the instruction communicates what it needs to with the first and second sentences, and it's a concern for us because the jury can, moral judgment and emotion are not necessarily mutually exclusive, and the jury is allowed to base its sentencing decision on emotions in favor of Mr. Holmes, if any. So we would ask the court to just omit the third sentence.
Any objection to that, Mr. Edwards?
Yes, Judge. The reason I didn't object to the last one was because the language was contained in this instruction. We believe that this instruction is important because it's basically a cautionary instruction to the jury that they can't do that.
And the second sentence in that instruction already discusses prejudice or bias and public opinion and community sentiment, which is part of the reason we felt it was redundant.
How about if I change it to your decisions in phase 3 of the sentencing hearing may not be the result of an irrational or arbitrary emotional response? It seems like the other parts of that are covered earlier in that instruction in terms of the bias and prejudice. What's the people's position with respect to that, Mr. Edwards?
We have no objection to that, Judge.
Ms. Nelson?
Our concern is that implies that emotion.
An irrational emotional response or an arbitrary emotional response. That implies to me that emotion can play a part in this. It just can't be arbitrary or irrational. So I read it as the opposite, actually. And I think the case law is pretty clear, too, about saying that the decision cannot be the result of mere prejudice, bias, passion, sentiment, conjecture, public opinion or feeling, or any other irrational or arbitrary emotional response. And it's saying mere, so it's saying, it can't just be the result of prejudice or the result of bias or the result of passion or the result of sentiment or the result of conjecture or the result of public opinion or feeling or just the result of any other irrational or arbitrary emotional response. If you prefer, Ms. Nelson, I'll just leave irrational or arbitrary emotional response, but frankly, I don't have a problem with that sentence. But I'll leave it to you without waiving your objection. What's your preference between those two? Yes.
prefer that the court amend it as proposed. But we would also, I think there was an instruction the court gave, if I'm not mistaken, at some point in phase 2 that said something along the lines of, you may consider sympathy for the defendant, but such sympathy cannot be something, and then it was something along the lines of what you have here, and we would ask that the court add something affirmative to this instruction affirmatively stating that you can consider sympathy or mercy for the defendant. About that, Your Honor. That was just my recollection.
I don't show the word sympathy at all in the jury instructions at the end of phase 2. I think the word sympathy appears in the standard model instructions for trial, and I think at your request we took it out before phase 1 because it generally tells the jury that it cannot make decisions based on sympathy. So that may be what you're remembering. But with respect to this particular sentence, I will amend it as Ms. Nelson has indicated, so it will read, your decisions in phase 3 of the sentencing hearing may not be the result of any irrational or arbitrary emotional response.
May I have just a moment, Your Honor?
Yes.
We would request the first sentence read, in reaching your final sentencing verdicts, you must treat the defendant as a uniquely human being and may consider sympathy and mercy for Mr. Holmes. I think that the omission, the sympathy omission from the second instructions was that you may not consider sympathy, and the court took that out at our request because it's our position that you can consider both sympathy and mercy for him, and that's particularly appropriate and important to point out to the jurors in phase 3. So that would be
mercy and sympathy for the defendant, but mercy, then he would read, but mercy and sympathy must be based on the evidence and information presented during the trial and the sentencing hearing. That sentence?
Right.
Ms. Nelson? Yes.
our position is as I stated previously, but without waiving anything, we don't object to including and adding the word sympathy in instruction number 2.
Okay, I'll change instruction number 2 as I indicated a moment ago. I think it is more appropriate to put it there, otherwise it's repetitive. So that sentence in instruction number 2 will read as follows. Each juror may consider mercy and sympathy for the defendant, but mercy and sympathy must be based on the evidence and information presented during the trial and the sentencing hearing. Anything else on the penultimate instruction, Ms. Nelson?
No, Your Honor.
Anything on the last instruction?
Your Honor, we would ask that the court omit the words penalty or, and just state any decision regarding the appropriate sentence on each count.
Okay. Anything else?
And then we would ask that the court omit the last sentence as redundant.
I think I took that from yours.
No. If you did, then we change our position.
Yeah, it's in yours. Then and only then may you begin to deliberate. It's also in the people's standard instructions. So do you want to leave it in? You still want to take it out? Do the people have any position on that? And by the way, you used penalty in that second sentence in your tendered instruction. I think the people did as well, and I added or sentence, but I don't see a problem taking out penalty or. The people don't have any objection to that, right?
No, Your Honor.
All right, what about the last sentence?
I think the last sentence is important because it says when they can begin to deliberate.
I agree. So over objection, I will leave it in. All right, is there for you, Ms. Nelson, any other instructions, introductory instructions that you want to tender?
No, Your Honor.
And any other objections or comments with respect to the introductory instructions?
No.
Okay, great, thank you. All right, let me talk to you briefly about the victim impact evidence then, if I may. All right, first of all, as a general matter, I understand that this is very difficult for folks. I get that. But I'm going to rely on the lawyers to make sure that they control the testimony. I know that's not an easy thing, but the lawyers are going to have to do that. And so the lawyers are going to have to make some calls in terms of who and I'm referring to the prosecutors, in terms of who they call to the witness stand, because there's no way around that. People have to follow my orders. People have to comply with my orders. There's no ifs or buts. While it's understandable that people may get emotional, they have to be under control when they testify. And if that's something that somebody can't do, then it's up to the people to figure that out ahead of time. And I've made some rulings with respect to the type of evidence that I'm allowing. So that's the first sort of global comment. The second is the defense, in response to P83, made some specific objections, and I have, for the most part, ruled on those objections, although I'm going to go through some things right now. But if there are any other objections, the defense has to make them and let me know that they're objecting. So, for example, I have not ruled on anything that's not based on some type of relevance or 403 objection. So if there is an objection beyond that, then you have to make it, and I'll rule at that time. In terms of 403 objections, although you made some specific objections with respect to that, it's hard to make those rulings in a vacuum ahead of trial. I did the best I could in the pretrial motion, but the reality is that I am in a better position to assess 403 objections when evidence is overwhelming and the jury's being affected. Then you're going to have to let me know at that point. I'm not saying that I will agree with you or disagree with you, but I will rule on whatever objections you make. And I'll leave it to you to decide whether you want to object or not. In terms of some of the disclosures that I have read, it seems like, Ms. Titch-McGuire, you have disclosed with respect to almost all, if not all of the witnesses, that they intend to talk about the last contact that they had with their loved one. And it includes the last, in some cases, the last phone call, the last text message, the last physical contact. You got to pick one. So I'll let you figure out which one, but I don't mind if people say this was the last physical contact I had with my loved one, and then you can ask if after that there were emails or phone calls, their relative being at the theater and finding out that they had died, that they did not make it. That testimony can get emotional and dramatic. So again, that should be brief. And the last thing is with respect to steps to find out what happened to their loved ones, what they did as they were trying to find out what happened to their loved ones. That kind of testimony can be emotional, and so it should be brief. There are a couple of people who apparently intend to testify that they have attended the trial throughout to honor their relatives. I'm not going to allow that. That may well be, but I don't know that qualifies as victim impact evidence. So a lot of people have attended the trial, and I don't think that should be admitted, even if it qualifies as victim impact evidence. Under Rule 403, I find that the probative value is substantially outweighed by the danger of unfair prejudice and by the unnecessary presentation of cumulative evidence, given what else the people have disclosed. There were some disclosures that refer to the events that trigger memories of the charged crimes. And I don't know what that means. It was separate from events that trigger memories of the loved ones. And it seems to me they're sort of one and the same. And so to the extent that it's all related to this, to things that remind people of their loved ones and how they died in the theater shooting, that's one thing. But if you mean something different, then you should approach the bench and we can talk about that, because I don't know what that would mean. I don't know what events there would be that trigger memories of the charged crimes, but not of the loved one. So I know that I've made a ruling with respect to media coverage and any references to media coverage. So that is out, and that I've explained why. To the extent that you intend to call more than one witness with respect to any victim, it can't be just repetitive. And of course, the defense will be free to make objections under Rule 403. I don't think there's an objection to the people calling more than one person. I think the maximum the people intend to call with a few witnesses or with a few victims is 2 witnesses, and it's only with respect to a few victims, 3, I think. So if there's an objection, the defense can make the objection, and I'll rule on the objection. But to the extent that I allow it, it should not be cumulative. In other words, it should not just be repeating the same thing. And then the last thing, global thing, and then I'll go through some more specific things. There are some disclosures that refer to the impact on friends. And the statute is not clear in Colorado that it includes friends. And I know that in Order P83B, I addressed this a little bit on pages 7 and 8. But, the statute refers to family. And I know that the defense had an argument that it should be immediate family only, and I rejected that argument. I don't think that there's any limit on a friend being able to testify, but that friend would have to testify about the impact on the family members and the impact, and also the individual unique characteristics of the victim. I don't think that at least I'm not aware of where the statute says that any impact on friends and co-workers and acquaintances or other people is also victim impact evidence that is admissible. Ms. Tisch-McGuire, am I missing something?
Your Honor, I think that the court has an excellent point. I mean, the statute says that it's any matters relating to the personal characteristics of the victim and the impact of the crimes on the victim's family. And you're right that there's no friend there. And then it says any such evidence, including but not limited to the testimony of members of the victim's immediate family. So I think the court's right that if we wanted to call a friend, perhaps the statute would allow that. But the people are happy to comply with the court's order and not elicit testimony regarding victims' friends.
And I don't know what the legislature meant by including but not limited to immediate family, because there it used immediate family, whereas in the sentence before it used family. So it's possible that what the legislature meant was immediate family, but also other family members, or it's possible that the legislature meant friends and co-workers, anybody else, but without any direct authority on this, I'm going to err on the side of caution. And to the extent that you want to call friends, they can testify, but I'm not allowing any evidence related to the impact of the deaths and the crimes on non-family members. Does that make sense?
Yes, Your Honor.
And again, friends can come in and say, well, I'm very familiar with this family, and here's the impact on the family. Friends and co-workers can also say, I was very close to the victim, and let me tell you about the individual characteristics of this victim. I think they can testify about that. I'm just not allowing evidence of the impact of the crimes on non-family members, okay?
Can I just clarify one thing, Your Honor?
Yes.
We do intend to elicit some testimony regarding the number of friends that victims had, which we think goes to their personal characteristics, that they were gregarious, outgoing, caring, loving individuals, and not the impact it had on those friends, but just that they had that many friends in general.
I don't see a problem with that. I agree that potentially or arguably goes to the individual characteristics of a victim. Again, if there's an objection, I'll rule on the objection, but that does not run afoul of my ruling. Let me see if there's anything else that's general or global. The last thing I'll say is I'm going to be watching the jury closely, and as this goes on, I'm going to be assessing how much I'm going to allow or not. You might remember that in McVeigh, at some point the defense objected because there was so much focus on just how the witnesses found out about the victims perishing in the bombing, the Oklahoma bombing, and also about the last time the witnesses saw the victims, and the last kiss and the last conversation and that kind of thing. And the court at some point, with the people's agreement, frankly, the people agreed to pull back on some of that evidence because the court noticed that it was particularly emotional and dramatic testimony. And so the court allowed it. I'm allowing it. I think it is admissible, but as we go on, I'm going to be assessing things to make sure that the jury is not overwhelmed with emotion, and to make sure that the jury's ability to make a reasoned moral judgment or determination is not interfered with. So in terms of the more specific things, with respect to Chantal, the victim's grandparents have cancer and are battling cancer without their grandson's help. I think that's a little attenuated, and again, given what else is in the disclosures, I'm going to keep that out. And that's pursuant to Rule 403, and based on my analysis of the probative value of the evidence being substantially outweighed by the danger for unfair prejudice, as well as the unnecessary presentation of cumulative evidence. With respect to Mary Teresa Hoover, apparently she's intending to testify about the impact of A.J. Boyd's death on his girlfriend or fiance, and I don't think she qualifies as a family member under the statute. So that's pursuant to my ruling, that would be out.
Your Honor, may I make records regarding these objections? Do you want me to wait until you're done with all of the specifics?
Why don't you wait until the end?
Okay, thank you.
And, she's been referred to at times, I think, as a girlfriend, and at times as a fiance. And so I'm not exactly sure, but I don't, at least based on my understanding of the statute, I don't know that is included. And again, I don't mind if she wants to testify and talk about him. She's entitled to do that. I just don't think that, at least under the statute, the impact that his death had on her is admissible. And if you have authority that you want me to disclosure. With respect to Sandy Phillips, I talked already about the attending the trial to honor the memory of her daughter. Again, I don't doubt that, but I don't know that qualifies as victim impact evidence. And again, under Rule 403, I'm keeping it out for the reasons I stated before. Under Rule 403, the probative value of that evidence is substantially outweighed by the danger of unfair prejudice, so I'm keeping that out as well. Again, given how much victim impact evidence that people have available, I also find that that would constitute the unnecessary presentation of cumulative evidence. And then there is also mention here of the impact on a good friend of Jessica Gowie, and I've talked about the impact on friends. with respect to Kathleen Larimer, again, there's an inclusion about attending the entire trial to support the memory of her son. Let me just say that the closest call on the issue of friends is with respect to Mr. Boyd's fiance. So that's obviously a close call, but the other ones, I just don't think under the statute, the way that it could reasonably be interpreted, that it comes in. Next I have Nora Wilwert, Wilwert. And I may have misunderstood this part of the disclosure, but part of the disclosure says that she intends to testify about her favorite memories of her 3 other siblings. So I'm not sure how that relates to the victim. If it's related to the victim's interaction with those siblings, then obviously it's fine. Is that what you meant?
Yes. Sorry, Your Honor.
Okay, then that's fine. Then, again, testimony related to attending the trial. I've talked about that. The impact on John Larimer's friends. I've talked about that. The next one I have is a disclosure related to Ms. Jerry Jackson that includes impact on Matt McQuinn's girlfriend and roommate. Same ruling with respect to those. With respect to Amanda Middick, it includes testimony regarding that her dad's biggest fear in life was that something would happen to his children and that it came true. And I wasn't sure how that went to impact on Dad. The impact is, as a result of the death, how has he been affected? I just didn't know how that connected to whatever fear he may have had ahead of time. So, and Ms. Tish McGuire, I'll give you a chance to address that at the end, but short of testimony of Tom Sullivan, in the disclosure, it says testimony regarding planning for all of their relatives to come to a funeral and making arrangements for all of the out-of-town family. Me, that this is the type of thing that people do whenever someone dies. And I didn't see what the probative value was with respect to that particular point. The media is mentioned here. I ruled a 4-year-old girl is an incomprehensible tragedy. My concern about that is I think it gets really close to the type of evidence that's inadmissible in terms of none of the victim impact witnesses are allowed to opine or testify about the crime or the type of punishment or the defendant's character. So when I read that someone intends to testify that this was an incomprehensible death on his life with the rest of the disclosure, I just didn't think that was appropriate, so I'm keeping that out. The media coverage is mentioned there, so I've ruled on that. Testimony regarding how sad it was that because Ashley Mosher was injured so badly, Veronica Mosher Sullivan's funeral had to be delayed, and because of the delay, family and friends who initially came out to support the family could not also afford to come back to attend the funeral. That seems to me more related to the impact of the injuries on Ashley Mosher as opposed to the death of Veronica Mosher Sullivan. So I'm keeping that out under Rule 403. Next, in terms of Ashley Mosher, I have something similar, testimony related to how difficult it was to have to delay the funeral of her daughter, Veronica Mosher Sullivan, so that she could take part in the funeral. Same ruling with respect to that. With respect to Karen Teves, I have, again, testimony related to attending the trial to honor her son's memory. Same ruling that I made before with respect to that. And then it says testimony regarding how she constantly wondered if her son was specifically targeted by the defendant in the theater. I'm excluding that. I think that calls for speculation, and I think, again, that gets too close for my comfort level to having an opinion about the defendant's character, to having an opinion about the crimes in question, so that's out under Rule 403. The next one I have is Ms. Weigel, W-Y-G-A-L, and in the disclosure it includes an entry for testimony related to how difficult it has been to grieve for her daughter when her daughter was part of a mass shooting that has been so publicized and so intensely public. She feels like this has inhibited her ability to grieve. Again, I don't question that may well be the case, but pursuant to my ruling on publicity and the media, that's out as well. Next, I have the disclosure with respect to Robert Wingo, and this is the last one. And this is it says testimony regarding his marriage to Rebecca Wingo. And apparently Robert Wingo was Rebecca Wingo's former husband and was her former husband at the time of the shooting. I just didn't understand what that meant. I mean, if he is going to come in and testify about individual characteristics of Rebecca Wingo, then obviously that's admissible. If he's going to come in and testify about their marriage in other terms, then that may not be admissible. So I highlighted it to talk to you, Ms. Stitch-McGuire, about it. Obviously, it has to be connected to the impact of the death, of Rebecca Wingo's death and the crimes on him. And if he wants to talk about the marriage they had, to describe the kind of person she was and how she acted and the qualities that she had and the traits that she had, I think that's fair. But I just didn't think if that included something else related to their marriage, so that's why I highlighted it. All right, are there any of those that you want to address, Ms. Stitch-McGuire?
Yes, Your Honor, and I also wanted to address globally as well some of your global concerns. I don't know if you want me to do that first or afterwards.
Either way.
Maybe I be permitted to sit here, Your Honor?
Yes.
Okay, I appreciate that. First of all, Your Honor, I know that the court is trying to strike a very careful balance to make sure that we protect this case. And the people understand that there's not a lot of Supreme Court case law that gives the court a lot of guidance.
There's not, and it's a particularly difficult job because on the one hand, I have to protect the defendant's right to fairness. I have to. I'm required to do it, and as a judge, I've taken an oath to do that. So that's not discretionary, and there is plenty of case law talking about how careful you have to be with victim impact evidence. On the other, I'm also aware of case law that says, hey, judge, the people are entitled to present victim impact evidence to show the harm caused by the crimes, and furthermore, the people are entitled to show the magnitude of the crime. And this is not a case like any other case that any of us have had, and it would be improper for me to treat it like that. And that's the difficulty. Where do you draw the line? And that's what I'm trying to balance here. On the one hand, giving you an opportunity to paint a full picture of the magnitude of these crimes and how many victims there are and what all is involved, how many people were affected, all of that. That's part of it. On the other, I have to make sure that this does not overpower the jury to the point where they make an emotional decision and not a decision based on reason, moral judgment, which is what's required. So I'm balancing those two, and I'm going to be watching the jury throughout the proceedings to do my best to make sure that both of those interests are given effect.
Thank you, Your Honor, and the people appreciate that. Citing from Payne v. Tennessee, as the court well knows, the federal constitution bars victim evidence only if it's so unduly prejudicial as to render the trial fundamentally unfair. And Payne also states the state has a legitimate interest in counteracting the mitigating evidence which the defendant is entitled to put in by reminding the sentencer that just as the murderer should be considered as an individual, so too to present evidence of his last phone calls with his parents, his last emails with his parents, his last contacts with his parents. And he was able to present evidence that his parents were in court every single day, except with the exception of whatever days Arlene Holmes said she wasn't present. And so in order for us to adequately counteract that mitigation that was presented to the jury, we feel like it's appropriate that the victims be able to talk about those things as well. So we would just make that record. Additionally, Your Honor, as to the court's question about media, we just wanted to clarify, we have some victims who learned about their children's death from the news. They turned on the television and that's how they learned that their children were murdered. Is that permissible if we don't talk about the other impact of media?
Yes, I haven't excluded that. What I'm excluding is any testimony about the impact of the publicity the case has received and the media attention these criminal proceedings have received. That's what I'm excluding. Because again, I think it's somewhat attenuated in terms of the impact. That's not to minimize what they have gone through at all, but it's it's attenuated in terms of the connection between the impact on the victims, which is very real, and the defendant's actions. And I know that there's not a requirement for a causal link. I get that. But I also could not find any case law that said this is allowable. I also could not find any case law that said attending a trial to honor one's deceased family members is victim impact evidence. So some of what I'm keeping out is because there's no case law that I see out there, and you have plenty, and I mean plenty, my previous rulings at this point, and I think it is appropriate for me to do that. So I am keeping that in mind. And regardless of whether that language refers to the defendant's opportunity to present mitigation evidence or whether it refers to the actual mitigation evidence that was presented, and I think it's the former, not the latter, but either way, I feel comfortable that these decisions are appropriate and strike the right balance. But you should know that I'm doing that with all of that in mind, that I have taken all of that into account. If you had one victim and you had one or two witnesses, I might have come out differently. But you have 12 victims here, and you're intending to do my best attempt to try to strike the right balance here.
Thank you, Your Honor. And the people appreciate that, and obviously the court understands this as well, but the people are in a difficult position as well because there's one person who's responsible for 12 murders, and that's the defendant, and the people feel like we still have to adequately present victim impact evidence as to each person who was murdered and treat it as they were individual murder cases to respect the victim impact to those families.
I understand, but it's not the same rules that apply to the two, and you know that. This isn't just coming from me. The rules that apply to mitigation are very different than the rules that apply to victim impact evidence. In terms of mitigation, the case law tells me to be as flexible as I can, to give the defendant every opportunity to present all the mitigation that he wants to present. In terms of victim impact evidence, the case law doesn't say, Judge, you should do bend over backwards to allow as much victim impact evidence as you possibly can. To the contrary, it says, trial court judge, be careful. Be careful because this evidence has a strong potential to evoke emotions, strong emotions. So you best be careful. And that's what I'm trying to do. So this isn't just because I feel like doing it. This is because I have to follow the law and I have to make sure there's fairness here for both sides. So in terms of the emails and phone calls and contacts and things like that, you're right. The defense had every opportunity to present a lot of those. But again, the rules are not the same. And by the way, there were some things that I excluded that I felt needed to be excluded even from the defense's mitigation point of view. So I did not allow everything, but I think giving you an opportunity to have people talk about the last contact they had, and they can pick whichever one they want, or whatever most significant contact they want to talk about, I will give them that opportunity. But they have to choose one. It can't be, well, here's the last email, and here's the last tweet, and here's the last, text, and here's the last physical contact. And again, this is my attempt to be careful, especially when it comes to that evidence of last contact, because I know that tends to be very emotional, dramatic testimony. And that's what the trial court judge eventually concluded in McVeigh, and the prosecution on their own said, Judge, we will stop. And so, anyway, go ahead.
Thank you, Your Honor. And Your Honor, the people concur with the court about the ruling about the friends. I would ask the court to reconsider both regarding Teresa Hoover's testimony about Los Samoa Cross. Los Samoa Cross was AJ's fiance. They secretly got engaged a week before the movie theater. And so I would cite the court to 24.1302 and the definition of victim's immediate family, which means the spouse, any child by birth or adoption, any stepchild, the parent, the step-parent, a sibling, a legal guardian, a significant other, or a lawful representative of the victim. And so the people would argue that Los Samoa Cross was most certainly a significant other of A.J. Boyk. And for the same reason, the people would request that the court allow testimony from Jerry Jackson about Samantha Yowler, because she was a significant other to Matt McQuinn. They were together for over 3 years. They moved from Ohio to Colorado to be together. And the only reason they weren't engaged was because Samantha was not ready to be engaged, but Matt had proposed to her on several occasions. So we would concur about all the other friends, but given the definition of victim's immediate family in that statute, we'd request those two exceptions.
Does the defense have a position on that? To P83, and in a footnote, footnote 8 on page 8, it says, Colorado Revised Statute, Section 18.1.3.1201, subsection 1B's reference to Section 24.
As to Chantel Blanc, the reason that it's actually impact that the grandparents are battling cancer and that Jonathan's not alive is because Kay and Tom Blanc actually raised Jonathan. Kay, K-A-Y, and Tom Blanc actually helped raise Jonathan Blanc. And I think it is an impact when you raise a child that you hope one day that they can care for you when you get old and sick. And they don't have other family resources, and the fact that
And when were they diagnosed with cancer? Before the shooting or after the shooting?
After the shooting. I would say for Amanda Medic's testifying, the court had a question about that Greg Medic's greatest fear in life was that his children would die. And you wanted to know how that was impact to Mr. Medic. And
what page are you on?
I'm now as a result of Michaela's murder, because he thinks that every single one of his greatest fears will come true, given that his worst fear in life did come true, that his daughter was murdered.
Okay. The defense objects?
Yes, sir.
All right. I'll think about that one too. What else?
As to Tom Sullivan testifying, I also just wanted to clarify one more thing. Mr. Sullivan actually asked the media to help him find his son because he was unable to locate his son.
Publicity the event and the case have received, not anything else. So that does not come within the scope of my ruling.
And then I would just ask the court to reconsider Ashley Mosier testifying about the fact that her daughter was murdered on July 20th of 2012, and she was not able to have a funeral for her daughter until October of 2012 because of the actions of the defendant. But for the defendant's actions, she would have been able to have a funeral.
If the jury hears that the funeral took place in October, the jury will make the connection. They're not stupid. They're very smart people. So I just don't, to me, that goes more to the impact that her own injuries had on this, not, so in other words, this is the impact the crimes had on her more than anything else. And so I'm still keeping that one out.
And then the court asked the people to clarify regarding testimony of Robert Wingo about the marriage to Rebecca Wingo.
Yes.
And it was as the court suggested. It was the characteristics that helped, is why he fell in love with Rebecca. The great reason she was a mother, how they co-parented even after they were divorced. And those were the things that the people are going to elicit, not and other things about their marriage.
Okay, great. That makes sense. Okay. Anything else?
Not regarding this, Your Honor. We do have some other matters to bring up to the court after these.
Okay, I will think about those two things that I mentioned. Is there anything from the defense with respect to the victim impact evidence and specifically the people's supplemental disclosure? I will think about the two outstanding things that I mentioned. I need to give that more thought. And by the way, going back to that family issue, the more I think about it, a significant other is family. And so it's consistent with common sense as well. So not only because it is specifically included in the definition of immediate family that is referenced in the statute, but also because just as a matter of common sense, a significant other is family, it's part of your family. So, all right, Ms. Brady, anything else with respect to victim impact evidence and specifically the people's supplemental disclosure, which I think I relabeled P83D as in Denver?
Your Honor, the court noted that the people intend to have more than one witness testify with regard to a couple of the deceased victims. And we would object to that. We would ask for an offer of proof as to what would be different or unique prior to them getting on the stand, rather than having to object in the middle of the testimony at the risk that the testimony would already have been presented to the jury. In addition, Your Honor, we would note that there are a number of offers of proof with regard to the victim impact evidence which tend to indicate that they rely upon hearsay. And so given that the court has ruled that the rules of evidence do apply in a sentencing proceeding, we do make a global objection to any evidence based on hearsay.
The people have already given the defense an incredible amount of detail regarding our witnesses' testimony, which was above and beyond what the court asked the people to do. We clearly understand the court's ruling that we're not allowed to present cumulative testimony, but it's hard. I agree with the court. It's hard for me to know if a mother decides to not talk about a story that then the sister also knows maybe the sister wants to talk about that story. And it may be hard to know until after that testimony. And if the court requires us to do so, we will do so. But we would prefer to not have to make an offer of proof, but we'll stand by the court's admonishment that we should not present cumulative testimony from those additional family members.
And Your Honor, I would just note briefly that in the prosecution's proffer in P083A, when they have cited additional witnesses for specific victims, much of it is just repeated from the witness before. So it's hard for us to know what is different about those witnesses and to know what we can object to in advance.
Yeah, that's the same concern I had in the disclosures that you made, Ms. Tisch-McGuire. There is a lot of repetition. Now, in all fairness, you made those before my ruling, so I understand that. So I'm not asking that you tell me and I can take any objections at that time. So again, I'm not asking for specifics. I'm just asking for categories, general categories about what you intend the second person will testify about. In terms of the final videos and photographs, are those related to the CD that I reviewed before, or is this something else, something different?
Your Honor, I believe the court has, in some totality, reviewed all of those photos at some point in time. The defense asked me if, as a favor to them, I would put just the victim impact photographs and the videos on one disc, which I did do, and I'm happy to provide that same disc to the court if the court would like. It was just kind of handy for them to just have all the victim impact photos together instead of as, they were discovered throughout the trial or throughout the 3 years.
Well, my recollection is that there was an objection that the defense made, and I looked at some videos and some photographs as a result of that. And then I sustained the objection in part, and I issued a ruling and ordered the people to modify the videos and the photographs. So are these different videos and different photographs than those that I've already ruled on?
Your Honor, I can tell the court what it is I'm specific. I have one additional objection to those videos. And then we have been given a number of photos from the prosecution, but it has not been identified to us specifically which photos they intend to introduce during this part of the trial. So those photos are also all on here, and there are at least, I believe, 75 photos, and I don't have objections to all of them, but I do have additional objections to some of them in particular. And now that we know which ones for which people.
The evidence being introduced, I'm trying to make sense of it, that's all. I remember that the defense made an objection to some videos and some photographs, and so then I ruled on those. And I think in my order, I specifically said that once the changes were made to the videos and the photographs, that if the defense had any additional objections, that they had to make a timely objection. I would not call this timely. So if it's related to those videos that were redacted already and those photographs that were modified pursuant to my order, then I'm not sure why the defense waited until now. And to the extent that this is related to other photographs, and I'm not sure why this wasn't brought up when I ruled on the initial video and photographs.
Your Honor, the only photographs that I recall the court ruling on are the photographs that are contained. Like one of the videos is a photo montage of like Mr. Cowden, or the photo montage of A.J. Boyk. These photographs are separate from those that are contained within those videos.
And you had not seen those before?
We have been given a number of photos by the prosecution, but they have not been identified to us as proffered within their 32.1 disclosures. They have previously said we're going to introduce some photos, but they have not given us any specific 32.1 disclosure of the exact photos that they're going to use. So we can't make a global objection to general photographs they've given us in discovery. They're required under 32.1 well prior to trial to let us know specifically what evidence they intend to introduce at the trial. And we received this last week in the midst, what was it? What day? I don't recall the day, but in the midst of our mitigation case. We did not have time to look at it or address it. We were able to do that over the weekend, and I am now asking to make those specific objections pursuant to my client's right to effective assistance of counsel to due process and a fair trial under both the United States and Colorado constitutions. If the prosecution had told us when their 32.1 disclosures were due, hey, these are the specific photos that we intend to introduce for these specific people, we would have addressed it much earlier.
And I ordered the people to modify the videos and the photograph montage for each of the, I think there was 4 victims that they had intended to introduce the type of evidence on, and I ruled on those, and I ruled based on the case law that was provided by the defense. So to the extent you're just making a record that you're standing by your objections, you're not waiving anything, and I ruled. So tell me about the pictures then that are separate and apart from that evidence that I ruled on.
Your Honor,
What are your objections?
With regard to the photos that the prosecution intends to introduce with regard to Alex Teves.
Yes.
There are 10 photographs in addition to the photograph that was previously introduced at trial. Of those 10 photographs, 5 of them are photographs with Amanda Lindgren Teves. We would argue that this is cumulative, and one of the dangers of unfair prejudice here, in addition to the emotional impact it has on the jury, is that the court will recall that Amanda Lindgren Teves was actually a victim in the theater as well, and the danger of highlighting her repeatedly throughout these photos also can point the jury to improper victim impact of the crime on her, aside from the death of Alex Teves. We think that 1 photograph is sufficient, but 5 is cumulative and unduly prejudicial under 401 and 403. And for the record, I will make all of these objections under Mr. Holmes' rights under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as the similar provisions of the Colorado Constitution. With regard to A.J. Boyk, the court is aware, having seen the video, that there are 27 photos already on the video itself, and there are 3 video clips as well on the video itself. The people intend to introduce, I think, 3 additional photos that are cumulative and represent similar photographs that are already being played on the video itself. And let me, if I can approach, Your Honor, I have thumbnails of the photos, and I can refer the court specifically to the numbers to make it more clear.
Okay, please.
Photos are 4672, 4673, and 4674.
All right.
With regard to Jessica Gawi, the court will remember that the video is of her doing a sports interview, and we believe that that is cumulative to 4689 and 4686, which also depict her in that same type of work environment. With regard to Jonathan Blunk, there are 6 different photographs of Mr. Blunk in various combinations with his wife and his children. We believe that 4695, 4696 are cumulative to 4691, 1692. Oh, actually, that might be 4692, 4693, and 4694. In addition, in 4697, there's a grouping of photos, like sort of a poster montage of photos. We object to that presentation of the photographs and believe that they're cumulative to the previous photos. And specifically, there's also photograph 4698, which is at his gravesite with his wife and 2 children. We object to that as unduly prejudicial. With regard to Matthew McQuinn, there are 2 photographs, 4702 and 4703, one of which is of his headstone, and I believe the other is of his casket.
Tell me those numbers again.
4702 and 4703. In addition, there are 3 separate photographs of him with his, actually 4 of him with his girlfriend, and that's 4699, 4705, 4706, and 4707. We believe to present all 4 of those would be cumulative. With regard to Gordon Cowden, the court is aware that the video for Mr. Cowden consists of, at this point, 29 photos. It is unclear how old some of the photos are, but we believe that the photographs contained in the video are cumulative of photos 4914 as well as 4718. With regard to Jesse Childress, we would inquire as to how old the photographs are. It's not easy for us to tell, and I know that the court has limited the people to photographs no more than 18 months old, dating back from July 20th of 2012. And the photos, I think, that I'm unclear on are 4719, 4720, 4721, 4722, and 4723. And with regard to Veronica Mosier Sullivan, we believe that 4732 is cumulative to the other photos, 4730 and 4731. And we also object to 4851. This is a photograph of her gravestone.
Hold on. Okay. What else?
4851 is a photograph of her gravestone, and like the other photographs of grave sites or gravestones or caskets that we've objected to, we don't believe that it is appropriate as victim impact evidence. We object under 401 and 403, as well as the constitutional provisions I previously mentioned.
Anything else?
Your Honor, we would ask to mark, I have another copy of the photo thumbnails as a court exhibit, as well as a copy of the disc that contains the victim impact videos. It also has the photos on there, but I think it's important to have the videos as they relate to the cumulative or 403 objections that we made in combination with the photographs.
Okay.
So I don't know what court exhibit number we're on.
Your Honor, I had a couple of court exhibits that I've already marked that I was going to ask to present to the court.
Okay.
And, I mean, I could renumber them, but I have 113 and 114, which I think are the next 2 pre-marked, and I was going to, after we were done with this, was going to ask to do that. So I would just ask they start with 115 with these.
All right. Why don't you do 115 for the photographs, for the thumbnail, and 116 for the disc. So the disc
ones, but yes, they're very similar to what the court has seen.
All right, thank you. All right, people's response.
Thank you, Your Honor. Your Honor, as to their objections to the photographs of Alex Teves with Amanda Lindgren, the people aren't presenting 5 photographs to show cumulative effect of their relationship. They all represent different events in the victim's life, and the victim impact evidence is supposed to give a glimpse of a victim's life, and that's what those photographs do. So the people would ask to be able to present all 5 of those photographs to the jury, even though they do have Amanda Teves and Alex Teves together. However, the defendant presented over 50 photographs of his family, and multiple photographs of his family showed him with his parents, showed him with his sister. And so the people don't believe that that's cumulative. They show different moments in a person's life.
Again, remember, comparisons to mitigation evidence, not very persuasive with me. I know you folks keep doing that, and, perhaps it feels unfair to you, but that's not the law. So it's not an apples to oranges comparison, but I understand your point. Now, remind me, with respect to Amanda, what injuries, if any, did she incur?
She incurred slight injuries, Your Honor.
Okay, all right, next.
And Your Honor, just for the record to reflect, I understand the court's position, but our point is that under Payne at Site 825, we are supposed to be able to rebut mitigation.
I completely understand, but the rules don't apply the same. You know that's the case. Mitigation rules are not the same as victim impact evidence rules. So,
Your Honor, as to A.J. Boyk's, the additional photographs, they are not all cumulative. One of the pictures is with his brother, and there are no other photographs of A.J. Boyk with his brother in the video that the people are going to introduce.
okay, what about the other two?
As to Jessica Gowie, again,
Well, hold on. There were three photos that the defense is objecting to with respect to A.J. Boyk, 4672, 4673, and 4674. And you said one of those is with his brother, right?
right, and Your Honor, they didn't give me a copy of their thumbnails, and so it's hard for me to know what these other two photographs were from memory.
Here, why don't you take my
Thank
copy?
you.
Great, thank you. It's 4672, 4673, and 4674. .72 is out by agreement, and 4674 is out by agreement, and then that leaves 4673?
Which is the picture with his brother.
Okay. All right, and you said that's the only one you have,
Correct, Your Honor.
including in the disc that I reviewed?
Correct, Your Honor.
Okay. What else?
Your Honor, as to their objections to Jessica Gowie's sports interview questions or interview photographs, the people would submit that they were different moments of her career that was
All right, Jonathan Blanc?
Again, Your Honor, these are pictures of his family and his children. He was murdered and left two very young, small children, and that's the impact. And again, these pictures are not just to show that he had a family, but they are to show the different moments in the family's life. And they also depict what kind of father he was. They show different events that he's doing with the children. And so it's not being offered from the cumulative effect of the family members, but the different moments in his life.
And what about 4698, which is apparently a picture of his family at his gravesite?
And Your Honor, the people would submit that all they have left, all of those little kids have left of their dad is a tombstone. And they go there once a year to honor their father. And that's absolutely an impact of the murders on their lives.
Does the case law allows pictures of gravesites?
It does, Your Honor, and it was cited in the people's pleading to the court.
Right, okay, what else?
And that they had also had objections to the grouping of photographs of Chantal Blanc, and the people would stipulate that we would remove that one photograph.
4697?
Correct, Your Honor.
Okay, so 4697 is out by agreement. Are there any other pictures of?
Your Honor, there are 9. That includes the photo that was previously introduced in the merits phase.
So 9, not including the thumbnail photos that we're talking about. 7 total. That would be 4695, 4696, 4691, 4692, 4693, 4694, and 4698.
Correct.
And does that include the one admitted during the trial?
It does.
Okay, so 7 total. All right?
Your Honor, that my count is different. I have 4855 as an additional photograph for him, but I could have that wrong.
That's the one that we introduced in trial, Your Honor.
So then it would be 8.
I apologize. It's rather the different moments that they shared that were part of Matt McQuinn's life.
And so, and how many photos are you intending to introduce of him?
Sorry, Your Honor, let me try to find my pleading and.
He wasn't included in the disc, correct?
Correct, Your Honor.
All right. What about Gordon Cowden? It sounds like there are 29 photos in the montage, and now there are additional ones to the 29?
There were some additional moments of the family that did not make it into the photo montage, and the people would ask to submit those additional photographs, but we would agree to take out the photographs 4914 and 4718 that the defense asked us to take out.
Okay, those are out. And then Jesse Childress.
And Your Honor, as to the defense's point, the court actually never made a ruling that the people had to not have just photographs of victims within the last 18 months of their life. The court ruled that we had to have in the videos that those had to be within the last 18 months of the victim's life. But I specifically inquired about this of the court, and you said that you wanted to see what happened in trial before you made that ruling and that you couldn't make it in a vacuum. So in terms of her requirement that I tell her how old the victim was in all of those photographs, that was something that the court had not ordered the people to do previously. And so we would ask that those few pictures of Jesse Childress's life, which basically depict the last 5 years of his life, frankly, be admissible, Your Honor, as we're not showing baby pictures, we're not showing pictures of when he was very young. It's just his initial entry of his career in the military and where he was based abroad.
And how old was he when he died?
He was 29 years old.
And so all the pictures are between 24 and 29?
I believe so, Your Honor, and I could verify that.
And you said this is because you want to show him in the military? His
career in the military.
His career in the military? Do you have any military pictures that are closer to the time of death?
I don't have any military pictures closer to the time of death.
Was he still in the military at the time of the shooting?
Yes, Your Honor.
All right, and then finally Veronica Mosher Sullivan.
Your Honor, the people would state that the picture of her gravestone make the same record that we made for the other victims.
All right, thank you. I'll take these under advisement, and I'll give you a ruling tomorrow morning. Is there anything else we need to talk about at this time before we adjourn, finally, for the day, Mr. Orman?
A couple of very brief things, Your Honor. And I'm not asking for an answer on this first one, but had Your Honor given any thought to the amount of time it was going to give the parties for closing arguments in Phase 3?
Not yet. Actually, I did give it some thought. You know I had given it some thought, Mr. Orman. I'll tell you my initial thoughts, but I haven't made a final decision because I want your input. My thought was that I would give each side 40 minutes in the initial closing and 20 minutes for rebuttal, if there is rebuttal, for a total of 60 minutes. Each side gets a rebuttal if it's appropriate, with the prosecution going first and the defense going last.
Certainly that's sufficient, Your Honor. It's probably, well, it is more than I think we need. I think the jury's probably heard enough attorneys talking to them. So if the court wanted to give us less time, we'd be okay with that as well.
Ms. Brady, how does 40 minutes and 20 minutes sound?
Fine.
Fine? Okay. Let's stick with that then, 40 and 20. You don't have to use all of it, obviously. All right. Anything else, Mr. Orman?
Your Honor, I have two items I would like to present to the court as court exhibits. One is C-TR-113, which is disc containing the PowerPoint slides that Mr. Brockler used in his closing in Phase 2. The other is reactions of the people in front of the bar when that occurred. So if I can just present those to the court so they can be part of the record.
Yes.
And I have copies for counsel.
Great. Thank you. Anything else, Mr. Orman?
No, Your Honor.
All right. Anything from the defense? Ms. Brady, do you have anything before we adjourn? Yes.
Oh, no, perfect, thank you. I don't know why I wrote that. I wrote the wrong thing. Oh. Okay. Here, there you go. It says right in there. That's all.
Your Honor, if I can inquire as to whether please.
First one was presented in printed format. I don't know why we would need both in a electronic format. So I was just given this and asked to present it to the court. I didn't create it or have anything to do with that.
Okay, why don't you talk to Mr. Brockler about it tomorrow and see what is contained in that disk and whether any additional record needs to be made. And if there's not a disk of the initial presentation, perhaps he has paper copies, or we can make paper copies part of the record, okay? Issues, there shouldn't be that much. Actually, let's have you come in at 9 just to be safe. Better that we wait, not that the jury wait. Let's have you in at 9. I'll give you rulings on the outstanding issues, and then we'll have the instructions done by then, the introductory instructions, and we'll have copies made for you and for the juror.
Well, it's been a long day. We appreciate all of you sticking with us through all of this. We are moving on to phase 3, and it starts tomorrow morning. The attorneys will be returning at 9 a.m. Of course, for us at 7 News, that means we're beginning our coverage, as always, just about 10 minutes prior. So 8:50 a.m. we'll start our live stream. We'll turn everything on, make sure it's all in working order, and we'll start with recap. Certainly, I think there's lots of interesting things to replay, not just limited to the phase 2 verdict, but we'll also have to consider talking about the list, for example, the list that I've posted on both YouTube and the Scribble Live chat rooms, list of filming, and for sticking with us through everything. We'll see you bright and early tomorrow morning. Good night.